Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Mail it, Murdoch stolen.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican, please, verbal fluffy.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for crumb's sake.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. It is wonderful to have you all here this afternoon. I might have a few things on my desk. I might have run to the store really quickly. Well, I pedaled to the store. I have some candy bars. I might use those in a minute. Let's see. Let's get Kim her prize. Hope you get a verdict today, Kim. I hope you get the internet today. Oh look, I win. Or you win. The internet, that is. Everything IP related worldwide is your responsibility. Congratulations, Kim. Thank you. The owner of the gas station where I bought these candy bars came out and thanked me for buying, I guess, so much. I guess this is where their profit margin is in the candy bar section. You wouldn't think so from the number of lottery tickets they were selling ahead of me in line. It took forever to get these, but we're here. We're here now. Did not get a Baby Ruth. Should I gotten a Babe Ruth? I got a couple. Yeah, I got some things. All right, we are on verdict watch. We are on verdict watch right now, which means that in court, where we have been all day this morning, everyone is waiting for the jury to do their job because they have been deliberating for how long, you ask? Great question. They've been deliberating for 1 hour, 30 minutes, and 45 seconds. The kids are going to be mad. The kids are not here. I'm telling you. All right, we'll get to these maybe in a moment. We have a couple things to do while we're on verdict watch. We typically do a little bit of court hopping because we need to be able to bail at any moment, so we can, return to the verdicts live or the question as the jury may ask one. Are you sharing the chocolate? No, I have a confession. I ate one of the Twixes already. I'm sorry, but they were not needed for the demonstration. It was just like a test to see if the chocolate was still good, and it is. It's really good. I did grab something that I need to not include in this analogy, or else it was going to go full politics, and that would be terrible. But for this example, we will not be using this Snickers bar. We're going to save this for later, just for don't even remember that one. It won't apply for an analogy, and if you do and try to incorporate it, it ruins everything. All right, candy bars for lunch. Yes. It was a test Twix. It was a king-size Twix. Never mind. It says share size. My bad. I'm sorry. But I figure I got on the bike, and I rode all the way to the store and back in this heat. That's got to be worth some points right now. It was an e-bike. I rode the bike. I may not have pedaled very hard, but I did ride the bike there back. Follow RA for more health tips. Who chews chocolate? Who sucks it? Don't forego the knife and fork for maximum enjoyment. I'm debating whether we should do a short that we can just keep on our channel with these, or I'm pretty sure I've got too much sugar in me right now. So I'm thinking that we do a short when the kids are here to eat the candy afterwards. But we'll explain it here on the live. We have a couple things going on. We have does this mean there's a verdict? No. What this means is we are waiting for the verdict. We are on the verdict watch. We are watching out for a verdict. If a verdict were in and we were still waiting for it, we'd call it a verdict warning. Is that how it works with weather? First it's a watch, then it's a then it's a warning. All right. Carol, hot in Florida. Welcome. Good to have you back. Did he cover the civil Karen Reed hearing today? Nexus Lexus, I thought it started in an hour, or 45 minutes. I don't think it happened yet. That's the leaked information hearing. I don't think it starts yet. I like to keep my finger on the pulse of everything that's happening. I like to think that I'm connected that way. I do watch 16 screens at a time, 17, 18, 19, 20 if you count these ones over here. So I do like to have a lot of information at my disposal, but a lot of it we don't go to. It's just for my own personal interest. But let's see. Unless you're diabetic, there's no such thing as too much. We didn't do the poll, Laura. That's what I need to do right now. I need to do this right now. Quick poll. How long will the jury deliberate? And I guess the 1 hour option is out. You know, I've always struggled with spelling, so polls are my nemesis. We're at 1:35 right now. That's not going to be a very popular option. 2 to 4 hours. I can do 2 to 5 hours. I've got some weird numbers in here, but just go with it. Let's see. All right. I think that'll work. We got a couple. There are really only two choices. But the options that are available to you are the following. How long will the jury deliberate? Less than 2 hours. So far, no votes. 2 to 5 hours. It seems like it's picking up quite a bit of the interest there. 5 to 10 hours, which would probably put us into tomorrow, has a bit of interest. And then let there be fireworks. That just means basically the holiday's going to be here before we get a verdict. So if you think we're going to be here all week waiting for this jury to figure it out, that would be your option. So go ahead and vote there. All right. Karen Dietrich, congratulations. You gifted a membership. That was really cool. We've had some generous gifters of late, so I'm not sure who specifically did that. Why are there two civilians on the top of the Empire State Building? They were like holding onto the tip of the lightning rod. They were right up there, above the light, above the flashy light. It was wedding proposal. No, it might have been some group called the Skywalkers that I believe they're mostly Russian, but they're like spread love from high elevations, not hate or something. I don't know what their actual motto is, but they do climb up and down tall things and reveal banners. I'm just impressed they brought the banner back down, right? That's what I'm most impressed with. And you've got to give them credit when they go to sentencing for this crime, which is a crime, public endangerment, felony, I don't know, something like that. When they go to be sentenced, they can be like, Your Honor, we realized our mistake. There in the thin air, it became clear to us this is not what we should be doing. And we took that banner down and said, I vow never to do this on this building again. And then they climb down. And that would be like, good, you've learned your lesson. So now we don't need as much jail time. Anyway, if they'd left the banner up, somebody would have to go up and get it down because it can't just be up there. It's not permitted. In New York, you know New York would be like, Empire State Building, we're going to cite you as long as that banner's up because you don't have a permit for that. You have to pay the fee down at the city offices. All right. Let's see. Fran. I see it. I got it. There we go. Done. One and done. All right, what's the next trial we're watching? The next big one we're watching happens early next week, which is the Tyler Robinson preliminary hearing, and that is going to be huge. And by huge, I mean CNN is going to be there. It's a big one. It's a really big one. Fun little fact: our little court our jailhouse takeover that we filmed 2 days ago here in North Carolina, that I was up on the scene for a little while. It appears to be all over the nation. I was seeing the news talking about it, even out on the West Coast now. So that was interesting. What did the banner say? Something about make love, not war, or free will. What was the post? They had a big banner. It was a kind thought, whatever it was. I think it was make love. No. When people. It was peace and love. I think they made it on like a bed sheet, a black bed sheet out of masking tape. So it was hard to read a little bit. Plus the wind was not being as helpful, which is probably good for them because you don't want high winds at the top of that. I believe love over power knows peace. Yes, a mathematical equation. Love to the square root of power equals peace, or that sounds like about right. Oh, Marina crosses. She was actually paying attention. When the power of love overcomes the love of power, the world will know peace. Oh, it's a Jimi Hendrix quote. Sweet. Shout out to the great, late Jimi Hendrix. I think the math one would have been good as well. All right. All right, we have a couple things to watch. First of all, we had Mr. Boyd back in Judge Dad's court today. We also had we've got Minecraft court with the guy getting the sentence I've never seen before. That just barely dropped it, so that we can jump to that sentencing as well. So we've got a couple things to talk about. Before we do that, though, I need to explain the candy bars so I can get them out of the way in front of me. Let me just put them in order the way they go. Oh, look, I have 4 extras. How convenient. Not for long. All right. While we wait for just a moment, let me get you. Box 2 is going to be camera 4 for just a second. There we go. Can y'all see my desk? We're going to go to Judge Dad here in just a second. Monday was a good watch. I need a link in Aurelia Julia. I need a link and a timestamp. All right. Some of you asked about lesser includeds. Lesser included is a legal term that for some of you just means that the judge is going to be reading a lot of pages before we hear anything exciting again. And that is true. It does take a lot of extra time to inform the jury about lesser includeds. Need to fix this camera. It's bugging the daylights out of me. A little brighter. There we go. All right. The idea is the prosecution comes in and they charge the defendant with the highest baking crime they think they'll be able to convict on. They say, we believe that the chef committed this crime in the kitchen. We have to meet the certain ingredients of this crime, and we think he committed a Snickers. And if the chef committed a Snickers, then there are going to be a couple things that the prosecution has to prove. They have to prove that, first of all, we have milk chocolate. Second of all, we have nougat. Third, we have caramel. And fourth, that we have the presence of peanuts. Those 4 things together would indicate that the chef committed a Snickers. But there may be, the evidence all comes out in court, and the jury, the taste testers, then consume the evidence and say, I didn't taste the peanuts. I don't think there were any peanuts in that recipe. And they have the option to say, okay, well, if you don't think he committed a Snickers, we believe then that you should convict him at least of a Milky Way. A Milky Way has chocolate, it has nougat, and it has caramel. And those three are present. We proved them. You can taste them all on your palate. You can try it again if you'd like. It's delicious. And then go ahead and convict him of the Milky Way, which is a lesser included. If he had committed the Snickers, he would have already also have included the Milky Way, right? Because the three things you have here also are ingredients for the fourth. But say for some reason they're like, caramel? You said something about caramel? That's the first I've heard of that. Then we have another option, a lesser included of Three Musketeers, where we go to the big screen because it's easier that way. Where you say, okay, say you couldn't taste the peanuts. We thought we proved it, but you didn't taste the peanuts. You say there's no caramel. You didn't find the sweetness in there. Well, we know that you had the nougat and we had the chocolate, and that would be a Three Musketeers. So please convict him of Three Musketeers. That would be a lesser included of Snickers and a lesser included of Milky Way. And if there's a holdout juror, it's just like, I heard you on the chocolate, but you said something about nougat, and there was none of that there. I got no nougat. You talked about it, I just didn't taste it. Well, there's another option. There's a lesser included. We could just go with a straight Hershey's bar. And a Hershey's bar would be a lesser included of Three Musketeers. Three Musketeers, a lesser included of Milky Way, and Milky Way is a lesser included of Snickers. In this case, we have the defendant charged with a Snickers and all these lesser included. So the jury can choose one of these lesser includeds and convict them on that charge. They have to choose the highest charge, the highest recipe that matches the evidence that they found in this trial. So that is how a lesser included work. And now I get to eat them. I think that's how they explain it in law school too. If the wrapper doesn't fit, you must acquit. And that is a great one. What about Almond Joy? I can tell you. Now you know why I did not use the Snickers White Edition for that analogy, because that would just go off the rails. Because it goes straight politics. Anyway, and now I need a Snickers. Not a sponsor. None of them are sponsors. So let me do this. Let me get us first down to Minecraft Court, where the Judge O'Donnell is going to be doing a sentencing here. We're going to do that one first. And let's see. Let me switch that over here. Box 2, cam 4, camera 7. There we go.
Thank you, Your Honor. We are present this afternoon in the matter of State of Ohio versus Marquise Thompson. This is 26 CR 514. President of the court this afternoon is the defendant with his attorney, Chad Mulkey. We were last here on May 27th. At that time, the defendant pled guilty to count 2, felony 3, failure to comply. The remainder of the indictment to be dismissed upon sentencing. This court ordered pre-sentence report, set sentencing court today. The state has had an opportunity to review the report prior to coming into court and is prepared to proceed with sentencing this time.
Mr. Mulkey.
Yes, Your Honor, we are prepared also to proceed to sentencing. I conversed with my client. I have also reviewed the pre-sentence report. Thank you, Judge. Please, the court counsel and others here in the courtroom today. My client is 34 years old. He is single. He has 5 children. He has his GED. He's indicated to me that he has something called a 608 certification, which is a license to work on refrigeration units. And he does residential refrigeration work on furnaces, air conditioners, things of that nature. Certainly we need somebody with that kind of experience out on a day like today. He'd like to have community control, Your Honor, so he can get back to work. The unfortunate obstacle in his life, and it has been since the age of 8, has been substance abuse, ubiquitous substance abuse.
It's too hot to lock up my client, Your Honor.
He's had some treatment in the past, but it doesn't seem to have taken hold. In fact, when the U.S. Marshals got him, or when the Marshals got him in this case, he was at Olympia Grove for the arrest on this matter. He knows that he needs to take care of his warrant in Garfield Heights from 2023, and that promulgated his fleeing in this case from the officer. He indicated that he was scared of the officer. I think there's some indication the officer had put his hand towards his weapon or on his weapon. Client was scared. Unfortunately, however, he's no stranger to not following the commands of law enforcement, as his past would indicate. But nevertheless, he would like an opportunity to demonstrate to this court that for future encounters, if there are any with law enforcement, that he will act appropriately, and also he won't be driving anymore because there is a lifetime driver's license suspension to be mandated in this case, so at least he shouldn't be driving anymore. So as a passenger, I think he will hopefully appreciate
Dude got his third
future
strike
encounters with
driver's
law enforcement to act appropriately. To that end, Your Honor, again, we would ask for community control. If NeoCap is part of that, I think he'd be willing to take advantage of whatever treatment he needs. He's indicated to me that his plan would include Concord Pines, Lake House, Ed Keating Center, and then sober living, following any and all aftercare instructions. There's also some mental health concerns, so we'd like to see those addressed too. Again, if he's placed on community control, he would like to be able to say that he'd be able to follow all of the court's orders, but only time would tell. So other than that, Your Honor, I don't have anything further. Thank you.
Mr. Thompson, what do you want to tell me before I impose sentence?
I would like to start by apologizing to the Willoughby Police Department for my ignorance and selfish actions by putting them in potential harm and danger. To the public of the city of Willoughby, I would like to apologize for solely thinking of self. I didn't realize I put hundreds of people in harm's way. I'm grateful that our higher power today kept everyone safe. To my family, for here is another time that I threw our trust away between us. I sincerely want to apologize. I pray we can rebuild again one day. I have done a lot of reflecting and self-inventory and seeing how selfish and dishonest I have been, and I'm not proud of it. If I can go back, I would just have faced my consequences as a grown man and then rather act out as a child. My impulsive and also fearful action of going to jail withdrawn was not worth the potential harm I could have caused. I want you to know I'm not building up a self-conscious defense against anything that I'm not willing to face up to. I'm just asking for mercy from you in the courts. I am a recovering addict that relapsed from not being honest about my mental health and also not being completely honest with my sponsor about me missing and still want to live the lifestyle. Now, today, I understand that the lifestyle doesn't miss me. I had 19 months of sobriety time before all this happened. The most beautiful 19 months I had in a long time. And the 19 months I had gained a home group in Akron, PPG, Primary Purpose Group, new friends, a loving sponsor. Also been in treatment centers to tell my story to other addicts. I assisted people like me to get clean and find hope again. I also graduated with honors at Fortis College and became an HVAC technician with Sheet Metal 33 Union under Crown Heating and Cooling in Uniontown, Ohio. I also gained a relationship with my family back. Sir, I believe I just slipped this time, but I stopped doing all the things that works. I believe if I had the courage to see myself as I really am, I would find out what is wrong with me, then correct it. Then I might have a chance to profit by my mistakes and learn something from the experience of others. For I know that there is something wrong with me. What I would have now be where I would have been if I spent more time analyzing my weaknesses and less time building alibis to cover them up. I got that quote from the author, Napoleon Hill, and what I received from that was be honest with the man in the mirror to become the man God intended him to be. Thank you for listening.
Where'd you come across that publication?
The Napoleon Hill book?
Yeah.
Here in Lake County, the book Think and Grow Rich.
While you were in jail?
Yes, sir. I went to an AA meeting, and a guy had referred me to read that book, and I read it through, and it was pretty neat.
All right, you were here previously in 8 years ago. Sent you to prison for 24 months. When is this 19 months that you tell me you were sober? What time period was that?
That was from, I want to say June to June 2020. 24 to February of this year.
Okay. So what happened in June of 24?
June and 24th, I got fed up with me just being out there on drugs and alcohol, burned through every bridge that I had. So I decided to move out of Cleveland and go to a recovery center out in Akron called Armada, where I completed a PHP and IOP program, transitioned over to a sober living house, and started to, work the program, get a home group, sponsor meetings. Then I eventually signed up for school, Fortis College, and started going to school, gained employment out there in Canton. I was doing good until...
Was that HVAC certification?
Yes. Then I was going to school, and eventually I started to miss the lifestyle again. I wanted to have a drink around Super Bowl. Well, actually, I didn't want to have a drink. I just wanted to go to the bar and just be in the environment and watch the Super Bowl game.
You can't do that.
About the time halftime come, I'm loaded. So, yeah. And then trickle down to me doing drugs.
What made you think you could go in that bar and sit there and watch a game without drinking?
I can't tell you. I thought I had the willpower. I thought I had it under control.
You can wrestle an alligator, but not in the swamp. The alligator
Isn't that
wins
kind of
every
an
time.
irrational thought?
Yes, it is, sir.
Okay. So where'd you go from there?
Just went to go look for harder stuff until I got back home that day and got into it with my living girlfriend, and she's in recovery too, and she decided like she can't do this anymore, so she kicked me out. I came back home to Cleveland, and the ball was on the road. Then I lost my job for not showing up to work because I'm not getting no rest at night because I'm out drinking and drugging. So.
I hear honesty in his voice.
But my job said if I find treatment, I was able to work something out with the union and them to receive employment again. So.
And did you do that?
No, sir.
Why not?
I continue to destroy my life. Neglecting my mental health had a lot to do with everything.
Okay, so what's your mental health diagnosis?
Depression, and I was supposed to go back to Laurelwood for therapy sessions to talk to somebody about...
When were you supposed to do that?
So I got out in like the second week of March, or the beginning of the second week of March, and I had an appointment, I think like the next following week to talk about some bipolar issues.
What about that Garfield Heights outstanding charge?
That's something that was new to me. Didn't
do
realize I had it. It didn't show up on no background check when I got my job. But most likely it was under the influence of drugs and alcohol. Just my past coming back to haunt me, sir. That's all.
Where were you working?
I was working for Crown Heating and Cooling out in Uniontown.
How'd you get that job?
I got it through, her name is Miss Barbara. She was a student job specialist at Fortis College, and she helped me with a resume, and I went in there and applied for the job.
So what did you do?
I was basically a residential maintenance tech. They give me a tablet with work every day, and I show up at the customer house and say I'm here with Crown Heating and Cooling to do maintenance checkup on your furnace or AC, rather what season it is, and I perform maintenance and do any repair that needs to be done to AC or furnace.
What was your work history before you got into that business?
Basically, at fast food restaurants and stuff like that.
That's a good jump, going from
Job
fast
to
food
job?
to AC.
Yes, sir.
Partying?
Yes.
That's why it was job to job all the time?
Yes, sir.
Okay. So, what was your life like from June of 24 through, when did you say it was, February?
Yeah, about
26?
Yeah, Super Bowl.
What was your life like after you sobered up and went to school, got a good job, compared to the previous life?
Well, looking back, I was very ungrateful, but now looking back, I was ungrateful, but it was great. I mean, I was going to anniversaries for AA meetings. I've been to 2 Founders Days. I spoke at men's meetings. It was good. It was a good life. But looking back, I was ungrateful at that time.
What do you mean you were ungrateful?
Because I always missed the party life. You know, I wanted to go back and be able to have that drink at the bar and wasn't honest about it. But now that I'm thinking about it, I wish I was just honest and just talked to somebody, and I wish I would have seen this ahead of time because I would have never had that drink, sir.
What was your involvement with AA?
I was a chairman before. Like I said, I have a home group. I have a men's group. I used to drive people to meetings from like rehab centers and stuff like that.
Chairman, what do you mean a chairman? What did that entail?
Like the chair, I get there and I open up the meeting. I find people to lead the meeting, like somebody had like 7, 8 years or over a year of sobriety, and they come tell their story. I introduce them and stuff like that.
How many times did you hear at those meetings stories of guys who said, you know, I stayed sober for a while and I thought I could handle it on my own, so I thought I could have a drink and shut it off there, but it didn't happen that way. How many times did you hear that?
All the time.
Okay, so what made you think you were able to get by that and be the one tenth of 1%?
That's an alcoholic for you. I don't know. It's the alcoholic mind of. Yeah, bumped my head pretty good this time.
So what, regardless of what I do, what do you need to do to get your act together?
Sir, if I was to be released today, my goal is to either go to Concord Pines, Lake House, or Ed Keaton Center, where I will be successfully completing their program, then transition to a sober living house, going to meetings, doing the 12 steps, and hopefully find a full-time employment job. And here from now on, just living a selfless life, because I've been real selfish and dishonest to my family, especially to myself.
He came prepared for this hearing.
When's the last time you had a sponsor?
Last time I talked to my sponsor was in the beginning of February. His name is Aaron McGee. He's also part of the primary purpose group out in Akron.
The judge changed how he streams. He doesn't like people watching his court minutes. I'm still looking for a sponsor. Yes, this is true. He's very convincing. And he's answering the questions appropriately as well.
When you were here for your plea, you said you were on Lexapro. Who prescribed that?
Laura Wood.
Okay. How much contact do you have with your kids?
I see them regularly. I talk to them regularly. I just got papers in the mail today for administrative hearing, July 7th, about child support.
Okay, Ms. Moore, anything you want to say?
Thank you for allowing me to speak today. I know that you probably received my letter that I spoke a lot in, but I do know my son's issues with drugs and alcohol. I know that he fought really hard to overcome it. And I saw his growth for a long time. I worried about him, but when I saw that, he completed the HVAC series, successfully, I love that he has a great relationship with the 3 of his children that's biological, and the 2 that he's just always adopted since day one. I love that part about him. If he doesn't have no money, I love that he takes me to the park, free stuff. He makes peanut butter and jelly sandwiches to make sure that they can have a picnic. I love about my son that
I'm going to crank this up.
When my mom was going through cancer, he was there. He made sure that she made it to her appointments that we couldn't make it to, you know, because of work, my sisters, my brothers. He was there. He was there to wipe her and clean her and everything like that. He's a good person that is fighting demons. I hope that there is some help that, you know, the Laurelwood or Sober Homes or whatever can give to him, because he's a good person that made a mistake, that was terrified at the stop, which I wish he would use his better thoughts. When I went around to help him pay his fines, to get his license back before, so he can drive for his HVAC job. I didn't see anything other than the fines that was paid. So I feel bad because I didn't see that Bedford, Mayfield, whatever location. He's a good person that deserves another chance. And if you can mandate that he gets these treatments, do me good. But a good person, and I just pray that God sees in your heart to do the right thing by my son. And thank you very much for allowing me to talk.
All right, thank you. Mr. Downing?
Thank you, Your Honor. The facts of this case, which I want to highlight for the court that I believe make this offense a dangerous one, aside from the fact that it's encompassed in the law itself, is the defendant did plead guilty to one count here. He gets the benefit of only having the conviction for one count, but this is two separate incidences that were separated by time and location. The defendant first fled from Willoughby at a traffic stop after handing his license over at speeds exceeding 60 miles an hour, which is well over the posted speed limit, crossed over into opposite lanes of traffic to pass a vehicle, and which caused the police to terminate the pursuit pretty quickly. He then was observed a short while later driving at a high rate of speed past the Willoughby Hills Police Department. They were unable to catch up to him due to his driving. And then eventually,
police department.
He was found on I-90 by the Wickliffe Police Department. At that time, was not being chased actively and was still driving at speeds between 90 and 96 miles an hour, approaching 100 miles an hour on a stretch of freeway, which I believe is 60 miles an hour there. Officers observed the defendant weaving in and out of traffic, and traffic was so congested that he actually had to slow down. So this was and this is at 3:53 p.m. So that area of Wickliffe is normally pretty busy. There's a lot of cars there, and so that even makes the defendant's actions more significant here. As officers got closer to the car, it increased its speed. It cut across 3 lanes of traffic. It exited the freeway. It got back on the freeway. Officers followed all the way into Cuyahoga County and eventually had to terminate the chase because they lost sight of the sedan because the last time they clocked it, it was going 113 miles an hour, which again is in a 60 mile an hour zone, so almost twice the speed limit on the freeway. Those facts in and of themselves are bad. And a lot of that is encompassed in the fact that he pled guilty to a felony of the 3rd degree. I think what is significant to the state here, in addition to what I already put on the record, is the defendant's history. By my count, he has 11 cases as an adult and a juvenile, 6 felonies, 11 misdemeanors. 2 of those misdemeanors are prior fleeing and eluding cases. 1 out of Willoughby and 1 out of Euclid in 2017. His active warrant through Garfield Heights is for a misdemeanor failure to comply case. So this is somebody who has a history of doing this. When he has been placed on probation, he has not been successful. There are multiple probation violations in his prior cases. He has double-digit traffic convictions. He had that active warrant through Garfield Heights at the time that he committed this offense, and he was previously sent to prison by this court in 2017. Just looking at this, there I cannot see how he would be a successful probationer. I certainly am sympathetic to anybody who comes in this court and with substance abuse issues. That is not an easy thing, and it's clear the defendant has issues and needs to get help. But from the state's position, regardless of any substance abuse issues, there comes a point where somebody's struggles with substance abuse cannot be an excuse for every criminal case, for all of their actions. And the defendant's actions here were dangerous, not only to himself and the officers, but to the public, and easily could have caused a serious accident, killed somebody. And at that point, I don't think there would be much of a discussion about his relapse or his substance abuse issues had somebody been seriously injured or killed. And so I don't think that's justified. His actions are dangerous. They are not justified. They're repeated actions. And I believe that prison is appropriate and necessary in this case. It's the state's recommendation that the defendant be sentenced to 36 months of prison in this case. Thank you.
All right. The
little different story there.
the actions are these actions are never justified. The drug and alcohol problem is never an excuse. So those are givens. Question is what you do with the individual who's sitting here based on these are terrible circumstances, as Mr. Downing has indicated. You've done this at least twice before, going back to 2017, twice in 2017, I think. 2017 in Willoughby. Yeah, both in 2017. You've been on probation before. You weren't on probation with me. I don't particularly remember the circumstances of that case, but I gave you 24 months in prison. You've been on probation in Cuyahoga before, after you were here. So ultimately the question is whether or not you're going to make any changes. So on the negative side is your record. On the positive side is, at least for a period of 18, 19 months, you made a change. Apparently your arrogance about where you were got in the way, and you reversed all that and dug yourself another hole. And as we discussed at the plea hearing, a big part of that hole is now a lifetime suspension, mandatory lifetime suspension. So you've got that hole you can't dig out of. You're stuck with that thing.
You're now a permanent Uber customer.
Question is what you're going to do so that beyond 34 years of age you stop coming back for this kind of stuff. Because it's all a simple solution. Okay, it's simple from the standpoint that you know what you have to do and you know the path on which it gets done. It's not so simple in the fact that you can't resist the urge, but you have to find a way to do it. There's no magic in it. You have to determine every hour of every day that you're going to do it, or it ain't going to be done. And there's no magic in those words. You already know that, because you've seen the worst of it, the best of it, and now you're back in the cycle of the worst of it. So I have reviewed the pre-sentence report and the letters I received in support of you, and I've considered the history that's contained in this pre-sentence report. And I have considered what you have said, what Mr. Mulkey has said, what Mr. Downing has said. I have considered all the relevant factors in 29, 29, 11, 12, and 13. I'm going to give you an opportunity for probation. I'm going to place you on 5 years of community control. And you're going to serve 136 days in jail with credit for 91.
Thank you, sir.
You're going to, the last 30, you're going to be in the jail treatment program. You're going to complete it and follow all the recommendations. After that completion, you're going to go to the program at either Lake House or Concord Pines. You're going to complete that program and follow the recommendations. After you complete that, you're going to go to a sober living facility for at least 6 months and comply with that program. You would have no drugs or alcohol, no illicit drugs or alcohol. And you'll be screened. You're going to obtain a mental health evaluation. And you're going to follow those recommendations. You're to go to only one doctor and one dentist and one pharmacy for any prescription medication. If you need to go to another doctor, then you must inform your probation officer so we know where you're going. You're going to take your medication only as it's prescribed, and you're going to sign releases so probation can get your records. And you'll pay the costs and supervision fees associated with this case. And at the appropriate time, you're going to obtain and maintain full employment. Mr. Tompkins, anything more as to terms?
I don't believe so, Your Honor.
You understand the terms?
Yes, sir.
Any question about the terms?
No, sir.
If you don't comply, the state will file a motion to terminate your community control, and if I find you have not complied, then you face potentially 60 months in prison. You understand that?
Yes, sir.
I'm also going to suspend your driver's license suspension. It's a mandatory suspension for your lifetime. Anything further, Mr. Downing? Remaining counts dismissed.
Meeting, sponsor home group, I don't know if that's something that...
Well, there's two things as to that. You're going to get recommendations out of jail treatment. You're going to get recommendations out of Lake or Concord. You're going to get recommendations out of the sober living facility. So you're going to follow those recommendations. They whether they recommend AAs, you've been to them, you've indicated to me they're of value, so it seems to me you ought to do it, regardless of who recommends it. Because ultimately, you have a roadmap to get out of your shitty cycle, and it's up to you to follow it.
It's a technical term. I'm not familiar with that.
So you got to do what you got to do. You know what you got to do. You just
It's like a
gotta
unicycle, but worse.
Anything else, Mr. Mulkey?
Not at all, Your Honor. Thank you.
All right, Mr. Thompson, it's up to you.
Thank you, sir.
All right. I love that he got a chance. This is his last chance. He's already lost his last chance when it comes to driving. He will not be driving again in this lifetime, at least not legally. Now we're going to jump up to, I know there's a Karen Reed hearing thing going on, and I'm sort of keeping an eye on that.
Because we had another one they were supposed to bring on after, too.
Hang on. That's this one. Hold,
to do, and when we get him back, we will take care of it.
Okay.
All right, I need the township attorney on Mr. Boyd.
This is Mr. Boyd case we've been following. He's the gentleman in the suspenders on the front row in the gallery. We've been following this one for a while. He has a yard that is overgrown.
A stick to adjourn that's up for tomorrow.
Okay.
It has a lot of old vehicles, old trailers, boats, and things like that.
I'm going to go ahead and sign this stip to adjourn.
It's been a
Mr. House sent over
25-year process to try to get this cleaned up.
He's got all these dates. What? You can't. If you have a problem scheduling a date, you tell me, Heather. I'm signing the stip in order. Mr.
Okay.
Boyd, Robert Thomas Boyd, 25B 82557. I'm holding my crossing my fingers. I'm crossing my fingers,
And
Mr.
my
Boyd,
toes.
that you did what I asked you to do. I know you didn't let me down this time. I've given you so many chances. Your name?
Yeah, DOB 82378 on behalf of Mr. Boyd.
Your name?
Robert Thomas Boyd.
Your name?
Rob Harris on behalf of Brownstown Township.
Your name?
Caitlin Floyd Carter with Brownstown Township.
A lot of names.
Do I dare ask?
Unfortunately, Mr. Boyd has made no progress since the last time we were here. He was also ordered, in addition to cleaning up the property, to at least contact the township to ensure that we get an inspection of the garage tear down. Hopefully, he didn't do that. He hasn't contacted the building department whatsoever. Kind of at a standstill here.
Well, Your Honor, the garage was torn down. It is my understanding.
That was before.
We got rid of one trailer.
That was before.
So, Judge, I know Your Honor, he's given Mr. Boyd several chances. He did have a summer cold over the last couple of weeks, so he wasn't able to do anything. But Judge, it's summer, so if he goes to jail, his neighbors, they have to keep looking at that stuff. Your Honor, I would just ask if the court would be willing to give him maybe a week or two just to see what else he can get done. I think if he wouldn't have gotten sick, then maybe he could have contacted the building department to make sure that the property could be inspected, to make sure the garage was torn down properly. But if he goes to jail for 80 days, his neighbors have to sit there for 80 days.
They can start an action. I don't know why you're making my position so difficult, Mr. Boyd. I don't know why. I asked you to get your son here. You said you don't talk to your one son. I asked you to bring your other son. He's not available on Zoom. He's not coming here, is he?
We're on the outs a little. The younger son.
You're on the outs with both of them?
No, my older son dropped me off today.
Then why didn't what is your older son? I wanted to talk to him. Remember when I asked you last time to try to get him on Zoom and I think you called him and he wasn't available? Why didn't you just ask him to come in here?
He's working 12 hours a day on midnights.
Can we try to get his son in here next week, Judge, before you decide if Mr. Boyd is going to jail?
I'm not sure you don't.
Get it, Judge. I know this was the cases from April 2025.
If this has been going on for how many years again? 25?
Something like that, Your Honor. I think it dates back to 96.
So it's only been 30 years. This new addition here was built 30 years ago. I don't know what to do with you, Mr. Boyd. At the risk of sounding crazy, I almost feel like I have to order you to get a psychological evaluation at some point.
I'm working on it every chance I get.
Psychological evaluation. I think this is deep rooted. I don't understand it. You could have a nice place there. You're not working on it every chance you get. You didn't call the township. You didn't go to the volunteers. You didn't bring your son in here. You are forcing me to do something I don't want to do. I don't know how much more clear I have been about this or could be about this. I don't know what to do with you, Mr. Boyd. You're the last guy I want to send to jail, but I don't feel like I have a choice. I just don't understand it. I do not understand it. Now I'm going to hear it's too hot. It's too hot. And it is too hot. I don't want you out there working on this. I don't think anybody should be working out in this crazy weather right now.
I can work in the morning and...
Mr. Boyd. What do you have on your wrist there?
I got carpal tunnel with both my hands.
You never wore those in here before.
Yeah, well, I wore them.
Did you ever wear them in here before? I never saw those on you. How many times do you think you've been in front of me on this case?
I always wear them.
I'm asking you, how many times do you think that you've been in front of me on this case?
I don't know.
Take a wild guess.
5? It's a wild guess.
It's wildly off. Judge, do the
I
math.
just don't know what to do.
Count with me.
This is at least the 10th time.
10. Count them.
Wow.
And I bet, oh yeah, I know. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Actually, I think this is the 12th time. Far cry from 5. And all I'm telling you is in the 12 times, I've never seen you wear those bands or wrists. Telling me,
Work you got done.
I'm just telling you the carpal tunnel syndrome thing I've never seen before. That's why I'm asking.
Yeah. I just wear them when it hurts. If it don't hurt, I don't wear them. Mostly at night.
Heather, put Mr. Crawford in a breakout room with Mr. Scott, will you please?
Okay, Judge.
I'm sorry, I didn't hear you, sir.
Shh.
No.
No, it's not your
I'm
turn
going
to
to revoke
talk.
the 771 status and enter the conviction. I don't have any choice.
Oh, man.
I don't have any choice. At one point on this case, I remember I did something that had everything that he was left to do, that he had left to do. I need to resentence him.
Maybe original sentencing on my.
All right. Why is that not attached? It should be attached to my order. I need you to
Fix it.
go to probation if you would. Go to Heather if you need to. Somehow, I need that attachment to the order that I prepared when I sent it. I am revoking your status. I am entering the conviction. I am going to resentence you. But I need to know what I originally had attached, because for whatever reason, it's not attached to the Register of Actions. And then I need you to take a second copy and you tell me what it is that I did or has been completed. And we'll have him back in a little bit. You're just going to have to be patient, Mr. Boyd, okay? Thank you. Okay, good.
So
we'll want that attached. Can you guys attach that to my sentence, please?
he's going to step down.
And
for a
then you're
bit.
going to give a copy to her that she's going to write on and indicate what has been done exactly, or you guys can, and we'll from there.
Okay, we're going to skip ahead to when he comes back in, which is about right here.
Track though. You're welcome.
Right.
Two 830s that haven't been brought back up.
Where's 2 830s that haven't been brought back in, Judy?
It's a miracle. I don't know who has them.
Are they here?
Yes, they checked in and
Well, let's go dig them out, will you, John, please?
I don't know who's Tomlin's.
Where's your lawyer?
Calling Ms. Patillo, too. In fact, I'm going to take a 5-minute recess. I need Ms. Patillo on this one, gentlemen and ladies.
I'll get her.
And I'm
Yeah, well, she was in Wythe County, but it looks like she's out.
we're going to call Mr. Boyd. I know you probably haven't had a chance to go through that. At least I didn't get it, and I don't want it right now. People against Robert Thomas Boyd, 25BA 2557. Mr. Boyd, your name.
Robert Thomas Boyd.
Yeah, Patillo, P.A. 207A on behalf of Mr. Boyd.
Caitlin Foley Carter, Brownston Township.
Rob Harris, Brownstown Township.
Do you have a document that you've had a chance to go through from the original sentence that tells me what is and isn't up to the satisfaction of the township?
Yes.
Can you provide me with a copy of that? And have you provided a copy of that to Ms. Patillo?
Ms. Patillo has.
Can I have a copy? I'm not going to sentence him today. I've entered the conviction. I am going to clarify with this. You're telling me, do you have a copy of this?
That's the original copy. I understand that he hasn't complied with any of them. Technically, I think the only one that's not relevant is book storage.
So when you wrote down F, what does that mean? So he has 2 vehicles parked on the grass still. There's multiple flat tires on the RV in the car. Winter boat storage only permitted on residential waterfront surfaces. You just checked an X there.
It's not relevant right now because not.
Ms. Patillo,
Yes, Judge.
I'm going to have you make a copy of this. We're going to make a copy for you. We're going to make a copy for the prosecutor. This is going in this file. I'd like you to sit and talk with Mr. Boyd. I realize the weather's going to be hot. Mr. Boyd, I'm going to shock you one day because I'm going to have to send you to jail for a long time, and I don't want to do it. I just don't want to do it.
We have audio live in Tennessee. There is some motion there.
You think I relish that? You think I'm a mean guy? I'd have to be a mean guy to want to send somebody to jail who's 78 years old.
If they do
but
anything,
you're kind of forcing me. Mother, give me 4 weeks out. We're to make copies of this. I want everybody to take copies, and I want a copy back in the file for me, so we all know what we're talking about. And Mr. Boyd's going to have it all done by July the 29th if we have a date then. I'm setting a sentence. Go ahead.
No, that works. July 29th.
What time?
We're open, Judge, whatever time you want to give them.
8:30. So Ms. Patillo, talk to him. You guys take this. I'm putting it on the top. I'm going to have you get a copy, Ms. Foley Carter and Mr. Harris get a copy, and we're going to leave a file copy in here.
All right, we're going to pause right there and jump right now to hang on 1 second. We're going to go right here. Why is that not working? Let's go here. There we go. We have motion in court. Not sure what's happening here. Waiting for the judge. But people have been called in. Let's see if we can see online. See if there's any indication as to what that is. Not seeing it yet. Could be a question. You got up in Massachusetts, you got a who's who of the Karen Reed case happening in that hearing. Lots of things going on right now. Ready to hear your jam?
All right, the court's staff's been made aware that the jury's arrived at a verdict, so we'll let them step down and announce it. Just out of respect to the jury, just keep your reaction, if any, to yourself, and we'll deal with it. All right?
That was fast. jury in Tennessee has made its way back into the courtroom after just 2.5 hours of deliberation in the Blaise Taylor trial. He's charged with murdering his girlfriend with an overdose of cocaine, also killing the unborn baby she was carrying. It was understood that the baby belonged to him. He said he was not ready for a baby. Testimony in the trial says that with previous girlfriends, he has pressured them or wanted an abortion, even taking one of his girlfriends to the doctor and being with her when she got that. The evidence came in over a number of days, 6-7 days of evidence, and now the jury just rapid decision where we're a little surprised here. So we have a verdict.
All right, ladies and gentlemen, the jury, the court just, and I say this just to reference to you by numbers. We start down at the far right and run down this way, 1 through 6, upper right, 7 through 12. So, Miss Juror number 7, you are the foreperson, and the jury's arrived at a unanimous verdict. All right, if you would, please, ma'am, stand and announce that verdict on behalf of the jury.
Wow, he doesn't review it first to make sure it's done properly.
We, the jury, find the defendant Blaise Allen Taylor for count 1, guilty of second-degree murder.
Second degree.
For count 2, guilty of first-degree premeditated murder.
First. So that was for first degree for the baby.
3, guilty of first-degree felony murder during the commission of a felony. For count 4, guilty of first-degree felony murder during the commission of a felony.
All right, if you'll turn that document in, please, ma'am.
That means that the jury felt that he was trying to kill the baby, but not necessarily trying to kill Jade. Second degree for Jade. First degree for, well, I guess the premeditation was for the baby. Second degree for
all right, ladies and gentlemen, the jury.
Jade.
You can back up just a second. Ladies and gentlemen, the jury, you've heard your foreperson, juror number 7, announce your verdict in this particular case, that you found Mr. Taylor guilty of, in count 1, second-degree murder, in count 2, first-degree premeditated murder, in counts 3 and 4, felony murder during the commission of a first-degree murder. I'll ask you if that is your individual verdict. If it is, you would indicate it is. If it's not, you would indicate it's not. Juror number 1, is that your individual verdict?
Yes.
Juror number 2, is that your verdict?
Yes.
Juror number 3, is that your verdict?
Yes.
Juror number 4, is that your verdict?
Yes.
Juror number 5, is that your verdict?
Yes.
Juror number 6, is that your verdict?
Yes.
Okay. Juror number 7, the foreperson, is that your verdict?
Yes.
Juror number 8, is that your verdict?
Yes.
Juror number 9, is that your individual verdict?
Yes.
Juror number 10, is that your verdict?
Yes, sir.
Juror number 11, is that your verdict?
Yes.
Juror number 12, is that your verdict?
Yes.
Okay. All right. Thank you very much. As you know, we'll need to discuss with the attorneys further issues in this case. Don't discuss the case any further. We'll get back with you here shortly. You can step down the hallway with the court officer.
I think this jury determines sentence, don't they?
All right, Mr. Taylor, you've heard the verdict of the jury in count 1. It found you guilty of second-degree murder. That verdict, as well as the other counts, guilty in count 2 of first-degree murder, counts 3 and 4, first-degree felony murder, will become the judgment of the court. In terms of counts 2, 3, and 4, there'll be the need for further sentencing hearings Does the state contemplate introducing victim impact statement?
Yes, Your Honor, upon the court finding that by the jury's verdict that we would be entitled to do that.
Okay. We'll take just probably a 15-minute break and let everyone settle down in terms of initial verdict. Come back and hear that proposed testimony under State versus Nesbitt, and then see Mr. Brand, Ms. Hollins, Mr. Joyner, what mitigating factors you want to submit or find that's necessary to submit to the jury. So,
the state's position is that Nesbitt only applies in death penalty cases.
What?
As far
Well, I'm
as
talking about as far as victim impact 403 analysis.
Under Nesbitt, if it's life without parole, there is a submit no analysis.
So you
there's no dry run unless it is a death penalty case.
You can just have whatever that may be overly prejudicial.
No, it will be victim impact under pain.
Okay. And does Mr. Brand, Ms. Hollins, you have prepared proposed mitigating circumstances?
Yes, Your Honor. I think there are mitigating circumstances, mitigating factors we would argue to the jury.
Okay. All right. If you'll get those.
We need a minute, probably.
Okay. Like I said, we'll take a short break. But let me ask the state this. There are cases with, obviously with the finding in count one, that wouldn't be considered by the jury. But there's also, I think it's Hargis versus State, that does apply to any felony murders that your notice that you submitted, the felony murder portion, I think it's your number 2, wouldn't apply in counts 3 and 4.
Disagree, Your Honor, because it is Middlebrooks. It is not a Middlebrooks situation. It is within the legislation that amended the statute post Middlebrooks, so that is something the state submits the jury can consider in a felony murder sentencing.
That an aggravating factor is the felony murder.
Which is based upon that aggravating circumstance, which is above and beyond just the definition of felony murder.
What do you mean by that?
Well, that the jury would have to find the aggravating circumstance that, again, that it is not a Middlebrooks situation, so that the state's position is the jury can consider that as an aggravating circumstance. That was the whole issue in Middlebrooks.
But there's some that would only apply to certain counts.
Yes, Your Honor, the age of the victim, certainly.
Right. All right, we'll take 15 minutes and then come back and hear from the defense in terms of mitigation.
Yes, Your Honor, the state would like to be heard or see
sure.
that.
Yeah, let them group Mr. Taylor, and by law, Mr. Taylor, your bond has to be revoked, so if you'll step into the back and talk with your attorney. Welcome to 15 minutes.
This last few moments out of handcuffs for Mr. Taylor. If they're going to revoke his bond, he will go back into custody today. The jury did it did the hard thing easily. Hugs from Jade's family. Relief with the verdict. Didn't see anything on the defense. I didn't get to see the family there. But the jury came back and said, Your Honor,
that was easy.
That was an easy one. That was an easy one for us. Judge is so intelligent, really thanks Ari for amazing sound coverage. And Wendy, thank you very much for a generous donation as well. Can't imagine what it was like sitting through this. Sitting through this trial. Hearing the defense argue that her friends, herself, and even her family were to blame in some extent. At one point, the defense hinted that the family was responsible for the death of the child. It's Nigeria. I think everybody's there. Stepmom, mom, dad, friends. There are tears, but also smiles. Jade's best friend, whose testimony played a critical role during this trial, she was the one that reported that she heard Jade say, "What did you put in my drink? Blaise, what did you do? I know you put something in the drink. I can taste it." That testimony was pivotal, as well as the testimony of a previous girlfriend of Blaise's who says that the Blaise came to her and said, "What can I give my current girlfriend to cause her to have an abortion? Maybe something I could put in her drink." Those two bits of information seems to be enough to take the jury to the beyond reasonable doubt point. This is a case I think has a lot of potential for appeal because of the judge's interactions. It seemed wrong. It seemed wrong when it happened. Courtroom Confidential comes in gifted 5 memberships. I'm wearing their shirt. I'm going to be on the show tonight, 7 o'clock Eastern time. We're going to be talking about this case, this verdict, as we talk about the Blaise Taylor trial. We were hoping that we'd save the verdict so it would be live on Courtroom Confidential. But thank you to the team, Josh, everybody over there. 7 o'clock, join us over at Courtroom Confidential. It's going to be wonderful. Attorneys are leaving. Blaise did not go with them. He has been remanded to custody with bond being revoked. We just have a 15-minute break here. This has been an interesting case. I found we've watched cases before where it appears that a judge has had a favorite. This one appeared very slanted that direction, where most of the admonishments, most of the sharp retorts from the judge were directed at the defense, and specifically at Letitia on the defense. That's problematic for me. Tiffany, thank you very much. I was wondering who was behind the keyboard. Can't wait to see you guys tonight. The jury reached this conclusion without basically any evidence that really linked Mr. Taylor to the drugs. There was just a big question mark with what happened there. I'm going to turn this audio down just a tiny bit in the courtroom. It's quiet. It's a lot of tears going on. A lot of tears going on there. We're not done. The judge is going to come back out. The jury is not released yet. I believe they will be handling sentencing as well. But circumstantial case, some people have a hard time with that, but when you think back, we've as a country, we've been dealing with circumstantial cases for a lot of years, and it's only relatively recently, in the last 20, 30 years, that we have really had a lot of hard evidence as cameras became more prevalent. Documenting ways that we can track and trace activities became more prevalent. The back in the day, it was circumstantial. That was basically how you did it. Very few times were people caught in the act with an eyewitness, and so it seems strange when we have a case now where there is just a lot of circumstantial, and we basically say, who else could it have been? The state never came out and said that, but with the timeline, they said that puts him there. That's the guy that was there. There's no other evidence that there was anyone else. I don't like that, because beyond reasonable doubt, there's someone else could have been there, right? Someone else might have, as unlikely as it is, might have happened. But I guess the reasonable part comes into play then. Death penalty on the table? I don't believe so. No, I think this is life without parole. Fingerprints were a thing back in the day. Yeah, that was fingerprints were at the scene. You're busted. They obviously found the best friend to be credible. Verdict, please. We just had the verdict. It goes like this. Jury came back guilty. 2 hours, 37 minutes of deliberation. And they came back guilty on all the counts, but the first count, which was the charge for Jade, first-degree murder of Jade, they came back with a lesser included of second-degree murder. That takes the premeditation factor out. Everything else would be the same. So I showed you the example of the candy bars where we're talking about lesser includeds, and all the elements of the crime would be in the Snickers. It has the nougat, the peanuts, the chocolate, the caramel. They found that one of those ingredients, the peanuts, were not present, and they went with the lesser included of the Milky Way. It still has the chocolate, the nougat, and the caramel. That would be the second degree, is what they went with on that one. So one level down. They're now an interesting argument. The state's made some arguments about some aggravating factors. And lucky for me, I prepared when we were at the shop to demonstrate, do the candy demonstration on Courtroom Confidential if he wants. The aggravating factors, that's where you start saying, hey, but this one is extra bad. This is extra bad. What do we have for that? Well, we have another Snickers, but it's extreme. This one has extra peanuts in this one. This is especially bad. So we'll hear some arguments about that. And here, if there's an aggravating factor that has to be weighed in the sentencing of that. Okay, we're gonna hold tight just for a minute and see if they come back, because it's just a few minutes they were going to be gone. Mr. Taylor may have some shiny new jewelry that he's wearing when we do come back. Let's see. You're slipping out of eating. Vivian, I'm not slipping. I just bought extras. That's what I did. I've got. This Snickers seems to be the shortened version because I already ate one of those. All right, so we're gonna drop Judge Dad, sort of where we left off there. We're not going to return there. Mr. Boyd is going to get a sentencing date. I think you guys saw the Mountain Dew. I might have. They were on sale. I gave in. Anyway, we're not going to return to that one. We might take a look at what happened briefly up in the Karen Reed hearing, because things got a little weird up there. I'm trying to figure out what's up. It might be over already, or it might be in a break, so I'm just trying to see where that went down. Leaked information hearing. Okay, we're going to hold off on that one just for a minute. Judge stepped in, was there for just a few minutes, and then left. So, are they going straight to sentencing? It sounds like there's going to be possibly victim impact statements that are given right away. So we're waiting to see if that happens right now. Is it the civil case for Karen? It's the leaked information hearing. So it's a. I think the attorneys are in the hot seat. All right. Tiffany, it is a lot to keep up with. I'm trying to avoid some of the drama that's circling around regarding that case, because the case itself, the underlying facts of that case, are interesting. The results, how that's playing through in the system, and right now, as we have, police officers state police officers who have text messages that are very troublesome. Those are coming out. Officer Good or Goody, I forget how he says his name. Those messages just came out. We already got Proctor's, and they're problematic. And they're problematic for the justice system as a whole, because you have these individuals who have been key players, if not lead investigators in numerous cases where we now have an obvious bias. We have all sorts of racist, sexist, misogynistic, fill in the blank situations at play where someone who was convicted using evidence that came in through one of those individuals might have reason for appeal, or might now be in a situation to say, I think the court needs to take another look at this, because the only evidence that was against me was from this person, and they now have shown their colors, their true colors. This could have far-reaching effects on what we thought were decided cases in the state. So it's going to be interesting. I don't want to get into the trash of the messages, because they're vile, they're foul, they're extremely offensive, and I understand. I've worked around police officers. They have a different sense of humor, right? You have to. You can't be around some of the stuff they see and be, and not become a little bit jaded to it, and not become a little bit desensitized, or have a relief mechanism that might be cracking a joke at a scene where everyone else is just devastated. I'm okay with that, but what we saw out of Massachusetts with these text message batches and information that's come out is way beyond that, way beyond that. So I think it does put a lot of decided cases in jeopardy. So, did you miss the verdict? You did, but we're not done yet. The judge has called a 15-minute break as defense is trying to sort out its mitigation factors, which sounds like something that would be announced at sentencing. So we might be going straight to sentencing on this one. It's a good circumstantial case. I think it was. Anyway, it's a problem. It's a problem up there. I think I'm not the one who's shouting that this is the tip of the iceberg. because I don't have evidence that the whole apple cart was bad. But we do have two bad apples that were interacting with each other, and that's probably not the extent of the badness in there. There's probably more that will come out as you lift under one rock and shine light into some of the dark places. You're going to see that there's more. But I'm not the one yelling that the whole system is corrupt from top to bottom. It might be. I just don't have any evidence of that. All right. Other than the glaringly obvious evidence about these two individuals. We're going to sit here for just a minute as we wait. If you just joined us, we have just heard a verdict as the jury deliberated for 2 hours and 37 minutes in the Blaise Taylor trial, where he was charged in the cocaine poisoning death of his he said girlfriend at one time, but I don't think that was ever the case, of his romantic partner, Jade, and her unborn child, Ivy. The state presented evidence that basically tried to, through a timeline, show that the only person who could have poisoned her was Blaise, and that she had no reason to poison herself, and that her friend had no reason to poison her, and that there was nothing else in that situation that would indicate there would be a problem. The one weak point the state had in their case is that Jade had participated at various times in the past in drug use. No evidence of cocaine that I saw anywhere else, but mushrooms, some marijuana, things like that, and she was still actively on that scene as far as providing some of that for friends or being the middleman, finding that from a dealer to get to people. So that was something the defense tried to capitalize on and say, look, she was, this could have been an overdose, could have come from anywhere. She was actively using, and tried to make her use of drugs, which appeared to be recreational, into something bigger than it was. But Jade's documenting of her activities and her change in her lifestyle once she became pregnant and was just so excited to have that baby, I think is what made the jury come to the conclusion that there was no chance in their minds that Jade would have even used the substance when she was pregnant willingly, used willingly that substance. So let's see. Hold, please. Let's see. We're waiting. Cocoa ethanol. I think the state should have gone on board a little bit earlier with the theory of how there was cocoa ethanol in her system. It would be very easy to say, we think that the cocaine may have been mixed with some alcohol to mask the flavor. Yeah, just that easy. We think that it may have been mixed with some alcohol to mask the flavor and to increase the potency. That could have been added or spiked to her drink and had the effects that we saw there. But it seemed early on in the case, the state was adamant that she had no alcohol because she was pregnant, and she stopped drinking when she was pregnant. She was not drinking, and they sort of were busy defending Jade with their argument, when instead they could have used that once again as a item against Blaise. What a trial. Do you think it will be overturned? No, I don't think it will. But I think the judge needs to dial it back a little bit. The reason why I don't think it will be overturned is because there were the appropriate instructions given to the jury to cure any problem the judge's behavior may have caused. I don't think, barring the jury comes out and said, we sat there in trial, wasn't sure what to do, but the judge made it pretty clear who was guilty. If they come out and say that, then yes, we have an instant appeal granted. But barring that comes out, and I don't think it will, the judge read the proper instructions. Everything was done properly. If the jury did perceive some sort of bias on the part of the judge, they're told not to consider it. Just the same way, if something was stricken from the record, they're told not to consider it. You'd have to prove that they did consider that, and that it would have gone the other way had that not happened. I don't think it'll be overturned, but I think that we will see a lot of the judge's behavior cited in his appeal, which I believe will be denied. Okay. Misjudged Dad, did he put Mr. Boyd in the pokey? I don't think so. I think he's revoked his bond status, and is going to sentence him, but the sentence might not include jail time. So that comes at a different date, I think. I'm impressed. I picked 2.5 to 5 hours. It was almost exactly 2.5 hours. That was, just over the 2.5 hour mark. So all of you who were in that category, which I think was over half of you, it's a great job. By the way, Loves True Crimes, thanks for your generous super chat. That is amazing. I appreciate that. Let me pin that, Amber. Thank you very much. Oh, you already did. Perfect. So glad the jury saw through the victim shaming. I don't like victim shaming because we're basically talking bad about somebody who can't defend themselves, right? You're counting on the prosecution to fight their battle for them, and the prosecution is not there to fight the victim's battle. They're there to prosecute the defendant. And some of that might look like they're fighting the victim's battle, but that's not their purpose there. They're not there to clear the victim's name or anything like that. So oftentimes a victim does get trashed in a court case, or their name get blemished, and then the only redemption would be in a conviction of the defendant. But I see at some point the defense does have sort of the right to put on a defense. And sometimes it can look like victim bashing. In the closing, Letitia from the defense got up and said she was not going to victim bash, and then she almost went into a list of things she was not going to say. I'm not going to tell you about all the partners that Jade had or her prior drug use. She sort of teased it by saying she was not going to go there, but she obviously want the jury to remember that, but didn't want to look bad in doing it. So not good that way. Let's see. Still waiting for them to come back from court. I don't see them yet. Just waiting for the judge. Verdict will stand. Circumstantial evidence is real. It's good. And we've got some good evidence in this case. I still think the state missed an opportunity by indicating that the results they got from Blaise's cell phone subpoena was a huge red flag. It was massive that they got all these old phones and devices that clearly were not currently being used, and some work phones and things like that. But it looks like they were given a bunch of stuff to think, oh, we fulfilled this, but the latest and greatest, the things that would be the other half of some of the conversations they saw with Jade or other people around that same time, we didn't hear anything about that, so don't think any of that was turned over. Joey Baseball, thanks for being a member. 1 month at the halfway point of 2026. Is the Corey Richlands trial your favorite trial of 2026 so far? That's a tough one. Let me think on that one, Joey Baseball. I've got to think for a little bit. Cornflake Girl, thank you for your excellent coverage. Thank you, Cornflake Girl, for the kind words. Wonderful that you're here. Still waiting for the court feed to come back as the cameraman's checking to see what he has on his camera. Looking at the saved files. We'll give him a moment of privacy in case he has something that we don't need to see. Why wasn't he required to turn over his current phone? Lost? Stolen? There are a lot of, think back to the Karen Reed trial. There are lots of things that can happen to a phone after it becomes an item of interest and before it gets turned over to the police. and any number of those might have happened. This was a good trial. I like the personalities in this trial, even though some were a little grating on the nerves. I do like a trial with strong personalities. That would have been blaming the boyfriend since she was there, not the victim, in my opinion, says Lisa. Phone got rehomed. The phone is because he lost the phone after she died. Yeah. Sorry, I'd love to give. I wish I could. I wish I could turn over my phone. Right? That's the fun argument where they're like, Your Honor, we've looked everywhere. We just cannot find it, and we want it for us, not because you guys have asked us and demanded it with a subpoena, not because it's court ordered to turn over. We want it because it has things that if we could find that would be our strongest piece of evidence, right? You can argue that way in front of the judge when the phone's missing, when it's gone, but if it somehow turns up for some reason, or iCloud backup from the day before, from current time just shows up on the cloud and found as a result of a subpoena, then you're in a world of hurt. Do you tell us how you voted in the poll yet? I missed it. Laura, the last poll we did was how long will the jury deliberate? 56% of you said 2 to 5 hours, which was right. 33% thought it would be over 5 hours, and only 4% said under 2 hours, so very, very close on that front. And then we had the Let There Be Fireworks, thinking it would go through the 4th of July holiday with the 7% there, just who liked the fireworks. But I have all these other phones, which mean nothing. All the work phones, all the old phones that have nothing on them, it's useless. No one loses their phone. I've lost mine occasionally. Always have my husband or daughter call me and find it that way. I'm curious if when Blaise was in the apartment, we have pictures of the drawings on the desk with the paper, like the takeout cup. Was that there when the police were? Hang on, they might be bringing the feedback. Was that there when the police were there, or was that takeout cup gone when the police investigated the scene? Because I don't think they found it, right? Or they overlooked it. I wonder if it disappeared when he went outside to look for the address. Somebody go there and look in the bushes, right? Somebody who lives there and has permission of the land. You can't just go search someone's property. This is a long 15 minutes. It is. We think we might be back in just a second. Yes, it was moved by the sink in CSI Photos. Okay, so it wasn't thrown away. Never mind. My guess is wrong. Thank you, Honorulia Julia, for your memory. I was watching the Karen Reed civil hearing. The judge summoned all 30 lawyers, read a prepared statement, walked off the bench, and didn't allow the attorneys to speak. I love it. We might go watch that. We might watch that. My sister left her phone in Vegas, and by the time we got back to Arizona, a man called and said his dad picked it up. He had picked it up. When is the verdict being read? About 30 minutes ago. Chloe's mom, you did miss it. It came in at 2.5 hours after they started deliberating. 2.5 hours, well, 2:37. 2 hours, 37 minutes. That is a boss move by a judge who orders all the attorneys to show up in person. People fly across the country to be there, and then you don't even allow them to say anything. Oh, that. AJ is not going to be happy about that. Should we watch the KR thing while we wait? Let me get that queued up for you. Okay, we can go there now if you want. It's going to be down here. I think we have. There's hot mic in the courtroom. Hang on 1 second. This is the Karen Reed show cause hearing. Let's see if we can speed this up a little bit. Just 1 second here. 1 second. Go a little faster. Right, just waiting for the judge to walk in. Should be any minute now. This happened just a couple minutes ago. This is a hearing where the judge is trying to determine who talked, how something leaked. And I don't know the details on this because I have not been following the drama. This seems to be more of a legal matter with less drama, although there will be drama incorporated in the legal matter.
Court, all right.
Yeah, this is
Court now session. We can see it.
15
Your Honor, may I
minutes.
proceed? Yes. Your Honor, for the record, Civil Action 2483 CB 0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III, et al. versus CNC Hospitality,
Okay, hold
LLC,
on.
doing business as CF.
Hold on.
Yeah. I was just saying,
The judge is back here.
The defendant was out, matter.
Well, sorry, we had to jump. This is live, Tennessee. The judge came back.
What is it? Your Honor, the notice that the state filed to seek imprisonment for life without the possibility of parole, based upon the jury's verdict in count 1, the state would move to basically strike our number 3 and what would be in the code section number 16, because that requires an intentional.
As to
The murder was committed against a pregnant woman.
Right.
And the defendant intentionally killed the victim. The jury's verdict of a knowing killing, I think, removes that as an aggravated.
from what would be, if it had been instructed at all, in count 3. Right.
Yes, sir.
Okay.
Yes, sir.
All right, so that wouldn't be, all right, now, any submission, Mr. Brand, Ms. Harris, on the mitigating circumstances?
Yes, Your Honor. As far as mitigating circumstances, and I've discussed this with Mr. Moore, we would submit that mitigating circumstances in section J1, that the defendant had no significant criminal history, would be appropriate in this case. My understanding is there's no objection to that.
Okay.
That's correct, Your Honor.
And then, I apologize, I don't know which number this is, but the catch-all provision that
Number
any other...
10.
Yes, number 10, any other circumstance essentially fairly raised by the proof in this case.
Does the state care to be heard on that?
Judge, submit under the law that has to be specific as to what that is, like a list of that the defendant graduated at the top of his class and those sorts of things.
Sure,
not just a catch-all.
Right, and so to specify, we would intend to put on proof related to Mr. Taylor's education, his high performance in school, his high performance in athletics.
You would?
We are going to.
Okay.
Yes, we are going to put on that proof today at today's
Okay.
hearing. His involvement in nonprofits, so community involvement, other essentially positive personal traits and background related to Mr. Taylor that would support mitigation.
Okay. All right, I guess we can discuss the language of the court would place in there once we hear the proof. Anything else before the jury's brought down?
No, Your Honor.
Give opening statements
A
and,
brief, yes, Your Honor.
okay.
And we would as well, the state.
Okay. And does the state, just again for court's edification, know how many witnesses you may be calling?
3.
All right, let the jury step down.
So now we have transitioned into the sentencing phase of this trial. The state is going to...
General Moore, the states, are you in agreement that the jury would be instructed in terms, well, I can ask this later.
Yeah.
dealt with victim impact statement not being an aggravated circumstance.
Certainly.
Yeah.
Caitlin, welcome to the jury. Thank you so much for your support.
And the jury can only consider that after they have found the existence of at least one aggravating circumstance.
So the jury will be instructed according to the state's question.
Get into an issue, the victim impact statements are not going to include any statement of what they want.
No, we've discussed that.
The jury may find, based on what the state's argued here before the judge, just very briefly, that because of the intentional killing of the unborn child, that would be the aggravating circumstance which could reach a verdict of minimum life without parole. So there's this is all on the line here. It's not a death penalty case, but it's the next highest penalty. That's potential here.
Or you can have a seat. All right, members of the jury, when we get to this portion of this particular trial, the law allows for the attorneys to give to you opening statements, then present proof, and I'll explain all this in the jury instructions. The parties are allowed to introduce appropriate, relevant proof to the issues for your determination in terms of the penalty that the state's seeking of life without parole, or whether it should be a life sentence imposed on the counts 2, 3, and 4 that you've rendered the verdict on. Right. Does the state care to make an opening statement?
Yes, Your Honor. Just briefly. Members of the jury, because of your verdict, we are now going into the second phase of this trial. And what the state will present is based upon, like it seems long ago that I read the indictment. In this part of the proceeding, the state relies upon aggravating circumstances that are named. And there are 2 of those presented for your consideration. Number 1, the murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older. See referred to Ayden. Number 2, the murder was knowingly committed, solicited, directed, or aided by the defendant, while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempting to commit any first-degree murder. Again, based upon your verdict. The existence of those circumstances have been found beyond a reasonable doubt for your verdict. That allows, at this point in the proceedings, for the state to present what under the law is called victim impact testimony, to give you a view into
the jury hears this.
Jade and Ivy's death, the effect it has had on her family, her extended family, and not going into really anything else. It's limited to that. Victim impact. And we call it 3 witnesses. Jade's aunt, Brady Moran, and who would have been Ivy's great aunt, Andrea Browning, who you referred to before, and Jade's mother and his grandmother, Bridget Burks.
Okay.
At the conclusion of that testimony, whatever the defendant chooses to present anything, this is why this is proceeding, that is submitted to your discretion. The judge will tell you the law, and once we conclude the proof, there'll be opening argument of the state. Perhaps the defense would have a chance, or they will have a chance to make an argument, and the state would close. Again, because we have the burden of proof throughout the criminal trial. That is the process, and that is what you will hear in this part of the proceedings, to allow you to, in your discretion, determine what the punishment should be for the 3 first-degree murder cases.
Thank you, Your Honor.
So the aggravated factor
Written
allows
opening
victim impact
statement.
statements.
Thank you.
Here comes the he was a good boy.
Always has been tragic. Nothing that anybody's going to say in this relatively short portion of the trial is going to change. And the thing we are going to ask you to remember is even if you find there's aggravating circumstances, and really the aggravating circumstances the state is going to ask you to find are based on your conviction here. Mr. Taylor's been convicted, there's no question. It doesn't require you to give him the harshest penalty ever. He's going to prison no matter what. The best outcome today is the rest of his life in prison, 60 years in prison, with maybe in 51 years he goes up for parole. He's 30 years now. At 80 he goes up for parole. That's the best outcome. You don't have to give him life without the possibility of parole. You can give him the opportunity to try for rehabilitation. You can give him the opportunity to work hard in prison. He's not going to. This is a tragic case, but it doesn't have to be the worst of the worst outcome.
Right, who's the state wanting to call?
Your Honor, the state's first witness would be Ms. Brandy Moran, and as part of the proof in this portion of the proceedings, the state would ask the jury to incorporate all of the proof that has been presented.
Okay, I mean, the law allows that. All right, let her step in.
Defense saying this is a tragedy, sort of sidestepping responsibility. And I realize it's an awkward position because, you know, he still is going to be arguing an appeal that this was wrong.
Testimony you're about to give to be the truth, so help you God. Yes.
This is the aunt, right?
Ma'am, could you please state your name and spell your first and last name for the court reporter?
Brandy Moran. BRANDIMORAN.
You heard me say a few minutes ago that you were Jade's aunt and would have been Ivy's great aunt. Is that correct?
That's correct.
And just so we're clear about the relationship, explain the family dynamics to us.
Well, she was my niece. But I was there with my sister the day she was born. I was in the delivery room when she was born. And for lack of not having children of my own for many years, she was like a daughter to me. My sister and I are very close, and so she was more than just a niece to me, and the same with my husband.
And just to be totally clear, who is your sister?
My sister is Bridget Benning Burks.
And so you have known or knew Jade from the moment she was born. Is that
The
correct?
first breath she took, I saw.
And throughout her life, did you remain in her life?
She, like I said, was like another child, or like my only child for a long time. In fact, she was 13 when I finally had my child, and she was less than thrilled that I was bringing someone into the world to take her place, which he never did. But we took her, my husband and I took her to Disney World for the first time. I took her on her first trip to New York. She loved to travel. She was full of adventure. We traveled Europe together. We were in each other's lives when she went to culinary school. She lived with my husband and I. So we were very, very close.
And where were you when you learned about the February 25th, 2023 incident?
I was at my home in Northwest Arkansas, and I was actually folding laundry. My sister called and said something's happened with Jade. I don't know what's going on, but we're heading to Nashville. And I immediately we talked for a little bit. She was in the car, And in the meantime, my husband was in the background. Northwest Arkansas doesn't have a ton of direct flights, and it's a good 10 or 11 hours from here. So he was getting flights for me, the earliest that we could get in Kansas City. And we actually drove all night so I could catch a first 6 a.m. flight out of Kansas City to get to the hospital.
Did you know before arriving at the hospital that Jay was expecting?
Oh, yes. I learned that Jay was expecting on November 9th, 2022, because it was my son's 10th birthday. And she had actually traveled to Arizona. I was in Scottsdale for work, and my work was wrapping up, and I was flying out my son, and Jay flew out, and my best friend, so we could celebrate my son's 10th birthday together. And so she arrived at the hotel, and I was extremely excited that my event was over with, and was ready to, relax, and, wanted to have a cocktail with her, and she kept refusing. And so she finally had to tell me without everybody being there, but she had gotten me a little bag that said only the greatest aunts become great aunts, and it had a picture of the ultrasound inside. So from then on, if you look at our text, every single communication after that was about this baby.
And so would it be fair to say you were looking forward to being a great aunt?
Oh, yes. I had already asked off work I didn't have to ask off work, I work remotely. I'd already informed my boss that from middle of June through when my son had to go back to school, I would be working remote in Nashville, helping her learn how to become a mom.
The jury has heard that she was removed from life support, she and IV on her birthday. Is that correct?
That's correct.
What was that like for you, yourself, going through that time?
It was probably, I thought, when my mother passed away a few years prior to that, that was the hardest thing I was ever going to go through. But nothing prepares you for what you see as your family's future going away. And although she wasn't physically my daughter, it was like losing a child. And not in a way that was fair, and especially at a time when my very last text to her was, "I'll see you on your birthday to celebrate." And that's what I was expecting that weekend before. I didn't expect to be driving to Nashville to experience what we experienced.
From the moment you heard, got to Nashville, saw what was happening, has there been a day that's gone by that you haven't had this on your mind?
No, it's completely changed. We have a small family to begin with, and it's taken away I won't say it's taken away happiness, and I've done a lot with therapy and grief, and it's never going to go away. But there's never going to be pure joy in the celebrations that we have, because there's always going to be one of the big pieces of our joy missing. So there's...
And with respect to the family, your sister, Brownie, people we have heard from, have you seen how this has affected them?
Oh, it's everything. It's how we operate in life now. It's even how I allow my son to do things, because we are a normal family. This isn't anything you ever think you're going to talk about. When I say we were boring people, and we liked it that way, and just, you can't let go of the fact that this type of thing now, really happens to other people. It happens to you too, and it can't happen to you. And so it impacts every decision, every thought. There's just across the board with my sister, with, our father, with my husband. My son was 10 at the time, and just trying to explain to him why somebody that was, you know, just like a sibling to him is no longer here.
I was going to ask about that, because Jade and your son would be what, cousins?
They were cousins, but they were
closer than that.
They fought like brothers and sisters, and she was 13 when he was born, and then she turned into his babysitter, and then, you know, she hit adulthood, and he had a little bit of a problem with her being an adult and not just his cousin Jade. So they fought like brothers and sisters, and there's just, it's really hard for me, like I said, because we have a small family, and my husband and I had our son late in life, and we don't have a lot of other relatives, and she was his only cousin, and he's not going to have her now later in life the way I've had my sister. Like, I relied on, you know, and she watched out for him. She could put him in his place like no other, and just, it kills me that I know that he's not going to have that anymore.
And have you seen that actually affect your son?
Oh, definitely. I mean, our entire family has gone through therapy. He had a lot of problems right when everything happened in school, just with behaviors. And I mean, it's impacted every single day since it happened.
Prior to this, was your sister, family unit, happy?
Oh, yeah, definitely. I mean, we were, you know, my husband and her husband are good friends. She and I are best friends, and like his children, like we all were just beyond just a happy, like I said, happy but boring, normal family. And there's just, I think somebody mentioned Jade's light, and that light's gone, and there's a dimness over our entire family that I don't ever see us getting back.
Can you describe, put in words, what you've seen this do to your sister, to Jade's mother, Happy's grandmother?
It's just destroyed her. When she talked about Jade being her life, she was her life. And every day, and aside from the fear and the hurt I know she has, I've lived with the fear of, like, is she going to be able to get back at us? And thinking about my sister not being here because she can't live without her daughter has been probably one of the hardest things that I've sat and just prayed and hoped that she is strong enough and will be strong enough, because I can't imagine. I can't. I look at my own child every Mother's Day, feel guilty that he's still here, and my sister doesn't have her little girl anymore.
There.
Thank you, Ms. Meyer. No further questions.
She has to.
Hang on just a moment.
The defense should just say
No questions.
No questions.
Thank you. You can have a seat. Who's the next?
The mic placement is terrible. We're getting terrible echo, and I have to switch between one set of mics and the other set of mics to hear the two sides. So it's difficult. Where that's just a statement, I could single it out and make it really clear, but I have to have both going.
Ms. Browning, could you please state and spell your name for the record?
Yes, it's Andrea Browning, ANDREA,
Ms. Browning, what was your relationship to Jade?
She was my bonus daughter.
When did you and Jade's dad get married?
2009.
When did you first meet Jade?
She was about 7 years old, which is how old my daughter is now, our other daughter, Ava.
And can you walk us through Jade's early life?
Is that okay?
Yeah, she was a little spitfire. The first time I met her, I'll never forget, because the light everybody keeps talking about, it's so obvious. And I was just, this girl was so full of life and so full of confidence. She she always had a smile on her face, and she was always ready for anything. And she adored her dad and her family. She just, you could see it all over her face, and her whole body lit up.
And Miss Browning, do you have another daughter?
Yeah, Ava.
How old is Ava?
Ava's 7 now. She was 3 at the time.
And can you describe Ava and Jade's relationship?
Yeah, that's tough because, you know, like I said, Ava has Down syndrome, and so she's developmentally delayed, and she didn't know Jade because Jade was in Arkansas when Ava was born, and it was also during COVID, and we were taking lots of precautions about who we were exposing her to. And she finally met Jade in, I believe it was 2021, and they looked into each other's eyes and knew that they were sisters. There was a connection immediately. Like, it was really eerie, but also amazing at the same time. But having her here was so great for Ava because she got to know her last year. And also the toughest part about it was that. That's it. That's all Ava gets of her was just that 1 year when she was 3 years old.
And what impact have you seen on Ava's life since losing Jade?
It's tough to tell her because she doesn't understand a whole lot about it, especially because she was so young at the time. But she's really into pictures, and she's always pointing Sissy out in pictures. And she asks about Sissy. She uses an AAC for communication. She just randomly hits Sissy on her words all the time. And it's got a little picture of Jade. And Sissy's always with you, so we can tell her and just keep explaining to her how great and wonderful her sister is and how much she loved her. And, you know, one of the toughest things I'll have to carry with that is that the Instagram post that Jade made that said, being in Nashville, one of the best things about being in Nashville is getting to watch my sister grow. And they will know her.
And can you tell us about finding out Jade was pregnant and how excited the family was?
They were so excited. I was initially shocked, and she could see that, and I think it was a short conversation, but we were automatically super supportive of her and super ready to do anything and everything, take her shopping, help her with decorating, help her with anything she needed help with. I mean, I had just become a mom myself not that long ago. And, you know, we talked a lot just about, you know, whatever you need, we've got you. And she didn't ask for much. She had a whole bunch. She knew she could do it. She's got all the confidence in the world.
And the jury has heard a lot about Jade's support system and how many people showed up to Vanderbilt and how many people took action that night. Can you describe for the jury Jade's support system, how many people she has here today, and what it's done to her friends?
I can't even begin to describe it because, like I said, she had only been here a year, and she was surrounded by people that were local, like at the end. I mean, obviously everyone from Arkansas came down, but the amount of people that came there that were not from Arkansas, that were there because she made an immediate impact on them, and they loved her so much, and they knew that this was going to be a huge loss to everybody.
And can you walk us through that night of February 25th and how you found out and how Jade's dad found out?
Yeah, I was actually asleep. I had a young child at the time. I had put her down a couple hours before, and I knew she was going to be up early, so I was sound asleep. And once I woke up, I saw the missed calls, and I was in such shock. I honestly don't remember a lot of like who called when, where, how. And I know Bridget had several missed calls from her as well as Dennis. And as soon as I talked to Dennis and got to Vanderbilt somehow on my own. That drive was awful. I could barely even operate my legs because I knew should have taken along with her.
And Jade was working at your brother's restaurant back in early 2023.
Right.
Can you describe the impact that her and Ayden's death has had on your brother's staff, your brother, just the restaurant as a whole?
Yeah. It was devastating. It's been really hard to watch my brother because he hired her. I mean, he didn't even hire her. He recommended her to the head chef, and it was a no-brainer for her to hire Jade. You know, he just got her the interview. But everyone at that restaurant, and that's the biggest thing is they knew Jade was not doing anything she shouldn't be doing. And they were always telling me that. About how great she was taking care of all the things.
I'm sorry.
Okay.
So here the defense, instead of objecting and saying, we object in front of the jury, which looks terrible, they instead say, Your Honor, may we approach? She was getting into the, I guess, a sort of hearsay testimony where she's saying the people at Jade's work knew that she was not getting into something she was not supposed to. That's the testimony the defense doesn't like. So that, I think that is outside of the scope of what she should be testifying to. So redirect your questions here. Next question.
All right, what's your next question?
There you go.
It greatly devastated him. I can just say that.
And Ms. Browning, is Jade's dad Dennis Browning?
Yes.
And can you walk us through the impact that Jade and Ivy's death has had on you and Dennis?
It's just been devastating, just knowing that Jade is only sister, and we know that she was always going to be around for her when we weren't, and it's ripped us apart. It's brought us closer together, but it's changed everything. We are very much more protective of Ayden now, having experienced what we experienced, and I know that it's just changed everything for us.
Those are all my questions.
No question.
No questions for the defense.
All right, who's the next witness?
Last witness for the state. It's going to
Bridget Burks.
be Jade's mother. This might be difficult.
You swear the testimony you're about to give to be the truth, so help you God.
Guilty across the board with the exception of, one lesser included. Went second-degree murder with the charge of, for Jade's murder.
Please state and spell your name.
And guilty as charged.
Bridget Megan Burks, BRIDGET, BENNING, BURKS.
And Ms. Burks, who was Jade then 18?
My baby girl.
And was Jade your only child?
Yes.
How can you describe Jade growing up and her light?
As soon as she walked in the room, you knew her. Because she was so full of life. She's known for being very loud. Got in trouble several times for being loud. So you knew her presence, her laugh.
And Ms. Burks, does Jade have a stepfather?
She does.
Okay, and what's his name?
Lynn Burks.
And when did Lynn Burks come into Jade's life?
She was 6.
And can you walk us through the impact that Jade's passing and Ivy's passing has had on you and Lynn?
We also have 2 boys, and so it just makes it harder, makes us worry more about our other 2 boys. That was his baby girl. You couldn't tell him any different. And it's just a void that will always be there.
Is your day-to-day life different without Jade?
Most of the time. People ask, are you okay? And I always say yes. But behind closed doors, I'm not.
And did you and Jade talk almost, if not every single day?
Yes.
And Ivy would have been your first grandchild?
Yeah.
Can you walk us through the impact of losing Ivy?
Well, I'm the youngest of all my friends, and I'm the only one that didn't have a grandchild. So I was excited to be able to say I'm a grandma now. I'll never get that opportunity because it was taken from me.
And is there a day that goes by that you don't think about Jade and Ivy?
No, every day.
These are all my questions.
Any questions?
No question.
Thank you.
Now we get into the mitigating factors from the defense.
Any other witnesses from the state?
No, Your Honor.
Any proof on behalf of the state?
Yes, Your Honor. Very, very briefly, I would actually call Detective Adam Reese, who I believe is in the court.
Okay.
Oh. Call another. Well, he was giving hugs to the family, to Jade's family and friends during the break.
Where the testimony about to give pictures,
Yes.
Detective Reese, as part of your investigation in this case, did you pull criminal history reports on Mr. Blaise Taylor?
Yes.
Do those include NCIC sort of nationwide background checks?
Yes.
In your investigation of criminal history on Mr. Taylor, did you find any prior criminal history?
No, I did not.
Thank you, that's it.
Any questions?
No.
Okay.
He has no record.
All right, who's the next witness?
Your Honor, we would call Evie Taylor.
Okay.
Okay, now we're going to get into the family of Mr. Blaise Taylor. This is the first time we've heard from them. Obviously, they did not testify during the trial. So these are also victims in this case, but victims on the other side. Their life is also sort of turned upside down, not to the same extent. If this is a mother or sister, let's see, looks like possibly mother.
It's Dr. Taylor, right?
Yes.
Dr. Taylor, can you please state your full name and spell it for the record?
It's Evelyn Taylor, EVELYNTAYLOR.
And Dr. Taylor, what is your relationship to Blaise Taylor?
He's my son.
And how many children do you have, Dr. Taylor?
2.
And is Blaise your older child or younger child?
He's my oldest.
And how old are your 2 children?
30 and 28.
So, Mr. Taylor is how old?
He's 30.
Where do you live, Dr. Taylor?
I live in Texas.
Can you tell us a little bit about who Blaise Taylor is?
Yes. He's the best son I could ever ask for. He's a loving son, a loving brother, a loving grandson, a loving nephew, a loving friend. never given me any problems. All throughout school, he was an A student. He was always the teacher's pet. In fact, his kindergarten teacher still keeps up with them to this day. He liked to help other children with their schoolwork because it just naturally came so quick to him. And the teachers would always comment about that. He loves sports. He wanted to follow in his father's footsteps, and so he played sports. Every time we moved, he made a lot of friends. He was team captain and leadership. He was a team leader. A lot of the parents would come to me and tell me that how much respect they had for him. He was a good student in the classroom and in sports, and he was the type of boy that they wanted their children to hang around because he was never getting in any kind of trouble and was very respectful.
Where did this, I'm gonna interject for a minute. Where did Mr. Taylor grow up?
We lived all over. He was born in Texas, but because of my husband's profession, we move every few years. So we lived in Texas. From there, we went to New Mexico, and then Louisiana, and then Tennessee, then Oklahoma, and then
Utah was in there.
Alabama, and then Arkansas.
Then Utah.
And is it fair to say sports are kind of a big deal for your family?
Yes.
So you mentioned he was very involved in sports. What sports specifically was Mr. Taylor involved in?
Well, his favorite sport was football.
And that's real big in your family.
Yes.
Right? When did he start playing football?
When he was 5 years old.
And how long did he play?
He played through college, and then he got an invite to try out for the New Orleans Saints upon graduation or after his senior year.
And he ended up not pursuing it professionally?
He didn't make the team, the Saints.
How did he, let's start with high school. How did he perform in football in high school?
He was a team captain in high school, one of the leaders on the team. He actually graduated early. He graduated a semester early so he can go to college early.
And you mentioned a little bit about his grades while he was team captain and playing football. How were his grades in high school?
All A's.
And then where did he end up going to college?
He went to Arkansas State University.
And I think we heard a little bit about that during the trial. Did he play football in college also?
Yes, he played football in college, and he actually graduated with his bachelor's and his master's degree in business in 2.5 years. He was the first college football player to ever do that. And while he was there, he started a nonprofit, the Power 102. He's very passionate about helping children in underserved areas and communities. And so while in college, he and his sister co-founded that nonprofit. And they just did a lot of community events for those children, mentored them. He was a big brother. He volunteered at the alternative school. And his senior year, I think he went like 3 times a week.
Does that nonprofit still exist?
The nonprofit still exists. They've actually given almost like over $90,000 in scholarships. They help each year. They do school supply drives for kids in underserved areas.
9,000.
They do Thanksgiving baskets and adopt a kid for Christmas for children that don't have resources to get presents for Christmas. Pretty much whatever the needs are wherever we live in the community. They just try to serve those children and just meet their needs.
And you said Mr. Taylor's sister was involved in that as well?
Yes. So if you talk to his sister Star, she'll say that he's her role model. She followed behind in his footsteps, and she's an A student as well. And if you ask her why does she make A's, she'll say because Blaise did. Why do you play basketball? Because Blaise did. From the time she was little, he would help her put her shoes on the right feet. When I was her coach, she would be looking at him, and even though he was only in junior high, she valued his opinion and wanted to hear what he was saying, what she can do better, how she can improve, whether it was in the classroom, whether it was with sports, whether it was trivia things or whatever. Whenever she needed advice, she would say that she would go to her brother.
And is Blaise's sister here? Has she been here?
She is. She has been.
Is your family close?
we're a very close-knit family. When we move a lot, we know we have each other, and then every time we move, we make several moves that we always find like adopted families wherever we are. Usually it's through sports. The kids under sports teams, and then they become a part of our family.
I know that this process has been very hard. Does Mr. Taylor have support still from your family?
Oh yes, he has support from our family. We have family members here. It's just hard because we're not from Tennessee. And we've had lots of different moves, so people that we're close to are in various states across the U.S.
So when Mr. Taylor started working for the Titans, which we heard a bit about, he was in Tennessee and you were still in Texas?
No, we were in North Carolina at that time.
You were in North Carolina. Okay. Did you have an opportunity, did you keep up with sort of how he was doing at work?
In work, yes. We talk regularly, and football's a big part of our family. That's what his dad does, so we have lots of conversations about work.
What's your impression of Blaise's work ethic?
He has really good work ethic. If you ask anybody that knows him, that's one of the characteristics they'll say. He's a hard worker. He's always on time. He'll be one of the first ones there. He's going to make sure that he gets the job done. He has a really good work ethic in everything he does, whether it was his schoolwork, an actual job where he's getting paid, whether it's a non-service, he always goes above and beyond.
Okay. How about, are there any other, we talked a little bit about the nonprofit, are there any other kinds of community involvement or examples that you can think about from Blaise's life, either recently or longer ago, that you can tell the jury about?
Well, he has a servant's heart, so he does a lot of community service. Usually wherever we live, like with his dad, the football teams usually do community service, so he can be involved in various things they do. I know one thing, like when he was in high school, where he was actually old enough to make a decision to do those things, he was really involved with the Miracle League. And so that's something he did throughout high school, with big brother type programs, mentoring younger children. He would do that. And then when he was in college, he just did a lot of community service, like I was telling you about, like for his nonprofit. But it was primarily through being a big brother and volunteering at the alternative school. So being a mentor, he had a little brother that was assigned to him, and he would bring him to football practice and let him watch. He would go to school and help him with his homework and do things of that nature. And then when he volunteered, I believe it was the 3rd grade classroom at the alternative school, he would just encourage them to do their schoolwork, to respect their teacher, and if they made their points for the week, he would come and he'd bring teammates, and then they would play dodgeball and things like that. And if they had a good week and a good report, he would let them come with him to, or he'd get tickets for them to come to a football game. And he was really involved with the community baskets, and we would do community Thanksgiving dinners. I think one of the things that I'm most proud of Blaise for was one time when he was in college, we were in church, and they were doing baptisms. And I didn't know this because he didn't tell me this. I'm just watching the baptism, and all the people come up and give testimonies. And it was a young college girl, and she said, "I just want to thank Blaise because he really shared about the Lord to me, and he's really instrumental in my relationship with the Lord and my baptism." And all the accolades that he had, like in the classroom or on the field, they were nothing compared to what I feel like he did for this young lady that said that she was a friend that just went to the university. And just the fact that he was instrumental in her being baptized, is those types of things that make me really proud of Blaise.
Dr. Taylor, one
A little bit of hearsay testimony, but
thank you, Dr. Taylor.
There's no complaint.
Let me ask this. Is there anything else you think you want to share with the jury that I haven't asked you about?
Your Honor, I would object to being that open-ended.
Okay. Then that's all I have.
All right. Any questions from the state?
No, Your Honor. Thank you.
State objects to carte blanche. Say whatever you'd like now to the jury.
That is the defense's proof now.
Okay.
That was the defense's proof. Now the jury has another job to do. instructions to follow.
Ladies and gentlemen of the jury, if you'll step down the hallway just briefly, we'll talk with the attorneys about legal issues and then right back.
Oh my goodness, I just need a little peace for a second. That was beautiful. Not a lot here. The jury can consider everything they heard during the initial trial as well as what they heard today in deciding the sentence. The two options are basically life or life without parole. There's not a death penalty on the table. But he's not going to get out of prison before he's 50. He's 81 years old. That's the soonest.
And just for the record, Mr. Bland, like we did the other phase of the trial, let Mr. Taylor step around and deal with his decision not to testify.
Another colloquy with Mr. Taylor. He had the opportunity to speak to the jury as well. Not in cuffs.
I do. Mr. Taylor, you understand that at the sentencing phase of the trial, you have an absolute right to make a statement to the jury.
I do.
You also don't have to say anything. You have the absolute right to remain silent.
I do.
And we have discussed that option and the pros and cons, and whether you want to make a statement at this point in time.
Yes.
And based on those discussions, you made the decision that you're not going to make a statement or otherwise testify.
Yes.
And that's your own decision.
Yes.
All right, he can have a seat. And then, Mr. Brand, in terms of the mitigating circumstances that I'd instruct the jury would be the defendant has no significant history of prior criminal activity. Set out the other mitigating factor raised by the evidence consisting of, and what do you contemplate the court instructing the jury there?
Trying to think of how to phrase this, Your Honor.
Right. I mean, excellent student.
I might.
What is the judge asking here? What mitigating factors do you want the jury to consider on this case?
What if we said, community involvement, prior acts of service, support system, and educational and personal achievements? That maybe in the ballpark?
It's a little tone deaf, but yeah, we can say that.
All right, community involvement, education, and personal achievement, and what was the other?
Acts of service.
Active service?
Acts of service.
Acts.
I wouldn't put personal achievement in there, especially
Does
when
the
he sort
state
of
care to be heard on that?
prioritized his personal achievement over having children. It's sort of like he's not ready.
Under the catch-all.
That's a tough
Okay, and I was planning on setting forth that catch-all about any other mitigating, but then consisting of and then listing.
Yes, Your Honor, I think that would be appropriate under the case law.
And then charge as to
These jury instructions should be a little bit shorter.
in terms of aggravating circumstances in counts 2, the murder was committed against a person less than 12 and the defendant was 18 years of age or older, and the murder was knowingly committed, solicited during the commission of the language there about any other another first-degree murder.
Yes, sir.
Accurate. And in 3, it would just be that felony murder type language.
Yes, sir.
And 4 would be both again.
Yes, sir.
Well, both
Yes, sir.
again. All right, anything further from the state in terms of jury instruction?
Not without having seen that.
Do you want 10 minutes before we come back with the closing arguments? And I can give you the draft.
5 maybe.
Just
Judge?
want to make sure that I don't say anything that's not going to be on the,
Okay.
in the charge.
Yeah,
Okay.
I would appreciate seeing the jury instructions, but we don't need much time.
Okay, all right, give the court just 6 minutes, maybe.
Okay, 6 minutes. We can deal with that. Judge steps off. This is a bit of a tough position for the defense. I'm going to mute them for just a second. This is a tough decision for the defense because they have the unfortunate situation of being in a room full of jurors who all think your client is guilty, and still having to acknowledge that guilt. First of all, say, "Hey, thank you all for not agreeing with me. Now please agree with me." But at the same time, have to walk this line because we all know that the defense right now is saying, appeal, appeal, appeal. This was wrong, this was wrong, this was wrong. None of them are in the contrite, you caught us. You're right. You're right. We thought we could get away with one. It's time to face the music. That doesn't happen now because that could jeopardize his appeal. So he's trying to walk the fine line of how contrite should we appear, knowing that we all think this was a travesty of justice, and we plan to and hope that this is overturned. So they're walking this line with the jury, who is deciding the fate of Mr. Taylor, and it could be the last time his fate is decided, if it's not ever brought up or granted an appeal. So it's a tough balancing act, and this is all just moments after they got the news that the jury was not on their side. I really wonder. I thought that the state had really dropped the ball in their case in talking with the jury, but it's possible that the jury who we only briefly saw, we only saw 8 jurors for a split second, and just through an accidental frame of a camera grab while it was panning. But I wonder if this jury, if the prosecution was reading them right, and the defense read them wrong in how they decided to go through with this, because they were consistent in their messaging from start to finish. I didn't see a huge a change in the approach of how they were handling the case or how they were trying to bring it up, with the exception of in the defense's closing, that weird little detour down the path about mothers love their children and no one loves children more than mothers. That was the only deviation, I think, that we heard from what happened in the openings. So, Bernadette, thanks for the kind words. If you want some great insight, tonight I'm going to be on with Josh from Courtroom Confidential. We'll be on the Courtroom Confidential channel, so please find us over there. It starts at 7 p.m. Eastern Time, and we're going to be talking about this case and the verdict that just came down. So do join us over there for that. Josh is absolutely amazing. The whole team is, I just love the whole family over there, and they are a family, the Courtroom Confidential family. They're wonderful. I'm wearing their shirt today. I'm repping it. And I was wearing it before they called me and said, "Hey, can you be on tonight?" So that's all good. So will we have time for the civil hearing when the jury goes to deliberate? Depends how long. I guess this is a 30-minute deliberation. The choice is just so narrow. The two options they have are life without parole or life. I think it'll just be a really easy decision for the jury here because the initial verdict was so easy for them. The civil hearing is 15 minutes. We've still got it queued up. We'll back up just a little bit to play that from the Karen Reed trial. We should have time for that. Definitely watch on Courtroom Confidential. It's so much fun. Hey, Mrs. R.A. is back from Raleigh. Yay, that's good. Hey, welcome back.
Thank you.
Love you. Okay. And while we're here, a shameless plug, we have a podcast that has nothing to do with true crime that we do on this channel every Thursday night. Thomas and I, Thomas is a good friend, longtime moderator, a true OG on the channel. We do a podcast here called the Not Relevant Podcast where we take a step back. Sometimes when we spend all day looking at court cases and, hearing basically the worst that society has to offer us day in and day out, it can weigh on the soul a little bit. So we take a lighthearted look at some of the news of the day and just have some fun. Generally, food is brought up. Tomorrow's going to be one of those food days. We've tested caviar before. It failed. I don't like it. We're going to test something that I will like more tomorrow. And both of us went to the store and got our test samples. So I'm not going to tell you what it is, but I'd gather all your little monsters around you. Come prepared to bring some fondue maybe. It's we're having cheese. We're doing some cheese testing tomorrow. So join us for that. It's going to be fun. I've got 4 kinds of cheese I've never had before. So we'll see what happens. I don't know what kind Thomas got. But I spent almost an hour walking around to the cheese cart at the grocery store, and I'm pretty sure they were about to call the police on me when I finally made my decisions. All right, about to put on my Courtroom Confidential shirt and prep for tonight's show. They have the best merch. They honestly do. I love it. I'm surprised that some people don't think circumstantial evidence is as powerful as direct evidence. It's the CSI effect, that darn show. Nicole, we were talking about that briefly, just because there have been trials where the evidence has been so good, right? Where we can watch the playback in slow motion of the crime being committed in 4K. When you have a trial like that, when you have like the smoking gun, first of all, your question is, why did this go to trial? It's obvious he's guilty. But the second one it ruins you for other cases, right? This is why I don't go fishing in Alaska. It's a little side note. If I go fishing in Alaska, I'm going to catch fish so big that I can never again go fishing and enjoy the little bait fish that I catch normally. We've been spoiled that way. We've been court watching in Alaska. Well, we have literally. That's a bad example. But we've got these big fish, this amazing testimony that's been given to us, served on a silver platter with sometimes great audio even, where we can see the crime and it's obvious to us who is guilty. It wasn't always that way. In the Wild West days, first of all, it was crazy to begin with, but juries had a much harder job to decide, and they did. They made decisions. I would say there were not many hung juries, but they made decisions back then. Now we have the DNA, we've got the cell phone pings, we have just all the testimony that we come to expect in a trial. We seldom get into fingerprints. It's more likely that we're going to get firearm tool mark testimony than fingerprints in this case. But maybe Mrs. Ari doesn't like Alaska. She does. It's not she has anything against the state. She just doesn't like cold. All right. We've seen tons of circumstantial cases, but something about this one doesn't sit right with me. And I don't know what. Katrina Bunny, that's okay. You might be in a minority on our group right now. But it's okay to be at the end of the case and have that I'm not convinced position. I think you'd make an excellent juror. If you listen to the evidence, if you sat through this and heard everything that was presented and just said, I'm not there yet, that's great. That's wonderful. That shows that you have a presumption of innocence, which is what we believe is a foundational doctrine in this whole judicial system, that everybody is innocent unless or until proven guilty. Unless and until proven guilty. Was he sentenced? Kellen, this is about to happen right now. The jury, the same jury that convicted him on these charges, is about to deliberate on the recommendation for his sentence. And they only have two options: life or life without parole. Both of them are very long sentences. Let's see. This case was simple. If she died 30 minutes before ingesting coke, he was the only one there. Either she did it or he did it. She called her friend to say he did it. That's pretty darn good evidence. Yeah, I got you ingesting. I knew what you were saying with that, Nicole. Typos. Been to Alaska 4 times because my sister lived there for 4 years. Now she lives in Florida. How many years until he's eligible for parole? According to the defense, it would be 51 years on a 60-year sentence before he's eligible for parole. Now, I'm not sure if that is just a number they pulled out of the sky, or if that's under the Tennessee rules, how the dates would fall. But defense says he would be 81 before he's eligible for parole. Let's see, I don't believe the state proved it. Let's see. I think the state did a really good job proving that that Jade would not have done this to herself, and that she was not engaging in drug or alcohol use herself. That means it has to be somebody else. If it has to be somebody else, we're left with 3 options, right? There can only be 3. She's seen doing just fine for dinner and everything else, so she made the chicken Alfredo. You've got Nigea, her friend Key, and Blaise. And Nigea and Key leave, and that window, according to the expert testimony, sort of meant something happened after they left for the cocaine to take effect when it did. So accidental would still have to be that she's taking it, right? She would have to be, changed from everything she's been doing. She won't even have a drink with her family who don't know she's pregnant. She won't. She's not doing anything with her friends. She's not partying. She's not doing the stuff that she did before. She's still buying and selling for her friends. So she still has contact with the drug dealer. But I just think that they did such a good job showing that she had changed her entire daily routine to ensure the best health she could for the baby, that there was no chance this was just like, oh, and then she decided to do some cocaine and took too much on that day. Fractured. The defense lawyer lost all credibility for me, and she tainted her witness credibility with me too. I completely understand where the not guilty people are coming from, even though I was in the guilty camp. That's wonderful. Thank you, Fractured. Appreciate your generosity too. He was kind of small to be a pro football player. The defense gave him an out when Mom was on the stand testifying just a few minutes ago about this, saying, oh, he got invited to try out for the New Orleans team. And he went down there, and defense is like, and he chose not to go that direction, right? And she's like, oh, no, he didn't make the cut. They didn't want him. Instead of saying, yeah, he pursued the management side of football instead of the player side. She's like, no, nope. They're like, nah, we'll pass. That was a funny throw your son under the bus moment. Are we on verdict watch? We are nearly on verdict watch for the sentence only. The verdict itself has already come in, and we're waiting for the jury to be charged with deciding what the verdict will be. This actually might be a verdict that comes in while we're on Courtroom Confidential tonight or shortly before. So that'll be fun to share that with Josh if it comes in live while we're on. I believe he didn't intend to kill Jade. Says surely not. Just to induce a miscarriage would have been cheaper to pay 18 years of child support. hindsight, 2020 being what it is, the jury agrees with you, surely not. They went with second-degree murder on that first charge. That first charge was for the death of Jade, where the state prosecuted at the first-degree level, and the jury found guilty at the second-degree level. The difference between the two is the premeditation. Is that, I tried to kill her moment. Yes, he did try to do something to cause the death of the baby. The jury agreed with that part, and Jade also died. That's where the second degree falls in. Let's see. Charlie Adelson's appeal was denied today. It was. But messy investigation. Cody, I'll give you this in this case. The investigation did have major flaws. And love the hospital, Vanderbilt, but it sounds like they also had some issues. I'm not sure if it's a school hospital, right? It's a teaching hospital. Are we dealing with a lot of interns and students that are doing some of the logging and the recording? Because there were errors. I mean, straight up errors about timestamps. There's questions, there's blanks where there should be some writing as far as what happened and when. And that we spent a lot of the trial trying to sort that out. And it gave the defense a lot of opportunity to, to cast doubt because of it. And that, we haven't even gotten into the fact that Jade's family and friends went in and into the apartment and what mayhem that caused in the investigation, which didn't really start until, at least on scene, until after they had been there. Wow, chat's all nice until someone disagrees. No, we're all good. We're good. We're back, actually. We're back with the judge. Hang on one second.
The jury instruction.
No, Your Honor.
Mr. Brown. Okay. All right, let the jury step down.
I agree there's a strong appeal. We checked this judge's record. He doesn't have a lot of decisions that are reversed. And that's the only indicator we really have for this. If a judge is often reversed, or the cases that go through him are often reversed, that would be an indicator, but he's like pretty normal. Blaise still not in cuffs. That should change after the jury comes back with its next verdict, though.
All right, you have a seat. All right, any closing argument on behalf of the state?
Yes, Your Honor, thank you.
This should be short as well. Expect 5 minutes or less.
Members of the jury, we're down to just about the last decision to have to make. And that is, what is the appropriate punishment in this case? I'm going to start out by saying that, yes, the judge will tell you that a life sentence, the state of Tennessee today, is 51 years before parole eligibility. That's a long time. It's a really long time. But, contrary to what Mr. Brand said about life without parole being the harshest penalty, the harshest penalty wasn't asked for, the death penalty. So, there are 3 punishments for first-degree murder in the state of Tennessee. One wasn't on the table. Life without parole is the next step down, and life imprisonment is the minimum sentence for first-degree murder. The state submits that
While there might not be a quantitative difference, who knows how long someone is going to live, but there is a qualitative difference. That is, what does crimes that you have found Mr. Taylor guilty of, what do they deserve? And you can consider, submit by your verdict, or mention this, you found the aggravating circumstances by your verdict beyond a reasonable doubt. That then allows you, and Judge Dozier will read the instructions, not nearly as long as the first one, that upon that finding, you can consider victim impact testimony. What this man's actions have done to the people who loved Jade Benning and would have loved Ivy and did while she was in the womb. She never got a chance. She never got a chance to know how much she was loved. Mr. Taylor, the judge will tell you to consider mitigating. Yeah. Before this, he had no criminal record. That doesn't mean he is not deserving of life without parole under the facts of this case. And again, going back to everything that you heard during the trial. Apple Benny. Apparently, Mr. Taylor was fine with helping out other people's children. He was a good student. No doubt about that. Very smart man, comes from a very well-educated family. A good athlete. Community service. And like I said, good to other people's children. That qualitative difference is that life without parole, the state submits to you, is the appropriate punishment. And you'll really have to decide that and come to on each count. But it is your decision, your collective judgment. There's no, oh, we have to prove this, we have to prove that. Once the existence of an aggravating circumstance is before you, and here we have to, then it is your call. And one of the things, victim impact, you've got, certainly, his parents didn't raise him to be like this. But the decisions that he has made were his alone. His family choose to do so. Visit him. So long as he is alive, talk, communicate, whatever. Because there's a saying, where there's life, there's hope. He's going to be alive. He's going to have hope. He's going to have that sense of living and associating and being, granted, not an environment that any of us would want, but it's of his own choosing, his own making.
The state might have stepped in it right
Jade,
here.
Ivy's family never have that opportunity. He took that from them 3.5 years ago. February 25th, 2023. He took something that
Defense should object.
no one is able to give back. And for that, on behalf of the state of Tennessee, submit that whatever hope of freedom that he should have, he does not deserve, and that he should not receive the minimum punishment for these offenses. Thank you very much.
I believe the state should not have been permitted to mention the death penalty for the jury to consider because it's not on the table. That was an improper argument, in my opinion.
Life imprisonment is an appropriate punishment for Mr. Taylor. And punishment is what it is. It is not a minimum get off easy kind of sentence. It is life in prison. 51 calendar years at best. That's if you make parole at 80, if he's 30 right now. Yes, in opening I said it's the harshest you have is life without the possibility of parole, and there is death penalty, but this isn't a death penalty case. We knew that at the beginning. It's the harshest option you are considering today. And life imprisonment is incredibly harsh. Living in a concrete box for the next 51 years, that is punishment. He's not getting off. He's not getting off easy. You're not letting him go. He's not walking out of this courtroom. Likely for the rest of his life. Now, looking at the jury verdict, it occurs to me that maybe there is some consideration from the jury that you all think Mr. Taylor intended to kill baby Ivy and maybe didn't have the intent to kill Jade.
You
But
think?
he knew he was killing her, or some version of that. Obviously, I'm not in the jury room. I don't know if that matters in your deliberation for this part of it. But if we're talking about what are the worst of the worst of the worst crimes that you get the worst of the worst of the worst punishments, this was a long, incredibly detailed, complicated trial. And you guys heard a lot. You can consider all that when you're making your determinations. The reason that we put on some proof about who is Blaise, what was his family like, what's his upbringing like, what's his community involvement like, is there's kind of a, I don't know if it's a saying, it's something that's talked about in work when you defend someone sitting at that table, that we are more than the worst thing we've ever done. We're people. Blaise is a person. He's got a family. He had a great childhood. He did well in school. He was an all-star athlete. Yeah, he did something horrific. Nothing that can happen here is ever going to change that. Nothing. And he's going to spend the rest of his life in prison no matter what. So you all can go home and rest assured that no matter what you do here today, he's going to spend the rest of his life in prison. It doesn't require life without the possibility of parole to send that message, to send that punishment. It's not either we let him off easy or we have to punish him the worst of the worst of the worst of the worst. He's being punished. He's getting the message. But he is not someone who has spent his entire life as a criminal. He is someone who's had a good life, who's done good things. I don't have anything to say about it. Did something terrible. There's, let's call it what it is. When you hear the jury instructions, there's going to be a lot of talk about aggravating and mitigating factors. And I said this in my opening, and I'll say it again. If you find aggravating factors, you don't have to find that he gets life without the possibility of parole. It's just something you can consider. Life imprisonment is punishment. It's life in a box. It's life in a prison. It's It is a message. It is a lot. It is enough. And we would ask you to return for your sentencing that be the appropriate sentence in this case.
Okay. I think I'm right here. I think that was a major faux pas. This should have been objected.
Very briefly, it's time to have this jury determine, does he deserve the minimum allowable? Or does this crime, these crimes, Mr. Brand argues this is not the worst of the worst. What could be worse than killing your own child and your own child's mother? That is my life without parole. Is an option in this case, and is an option the state of Tennessee would respectfully request you consider and return. Thank you. Thank you, Your Honor.
I think they stepped in it. Tennessee Code 39-13-204.
Found the defendant Blaise Taylor guilty beyond a reasonable doubt of murder in the first degree as charged in counts 2, 3, and 4 of the indictment number 2024A490. It is now your duty to determine within the limits prescribed by law the penalty which shall be imposed as punishment for this offense. Tennessee law provides that a person convicted of a murder in the first degree shall be punished by imprisonment for life without possibility of parole or by imprisonment for life. A defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravated circumstances proved beyond a reasonable doubt and any mitigating circumstances which may have been raised by the evidence throughout the entire course of this trial, including the guilt-finding phase or sentencing phase or both. The jury is the sole judge of the facts and of the law as it applies to the facts in this case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by the law, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given the evidence. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to show the financial, emotional, psychological, or physical effects of the victim's death on the members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant, not an emotional response to the evidence. Victim impact evidence is not the same as an aggravated circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstance which has been alleged. You may consider this victim impact evidence in determining the appropriateness of the sentence only if you first find the existence of one or more aggravating circumstances as has been proven beyond a reasonable doubt by evidence independent from the victim impact evidence. Count 2, statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances which shall be limited to the following. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. And 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempted to commit any first-degree murder. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Members of the jury, the court has read to you the aggravated circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravating circumstance in deciding whether imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. The defendant has no significant history of prior criminal activity, and 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character, any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. Count 3, the felony murder involving J. Tristan Denny, statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or is fleeing after having a substantial role in committing or attempting to commit any first-degree murder. The definitions of knowingly, intentionally, which apply to this offense have been previously explained to you in these instructions, and you should refer to those definitions as they apply to this offense. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravated circumstance in deciding whether imprisonment for life without possibility of parole would be an appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. 1, the defendant has no significant history of prior criminal activity, and 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspects of the defendant's character or any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. Count 4, felony murder involving the victim, the unborn female child of J. Benning. Statutory aggravated circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more statutory aggravated circumstances which shall be limited to the following. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit or was fleeing after having substantial role in committing or attempted to commit any first-degree murder. Definitions of knowingly and intentionally which apply to this offense have been previously explained to you in these instructions, and you should refer to those definitions as they apply to this offense. Members of the jury, the court has read to you aggravated circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravated circumstance in deciding whether the imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. 1, the defendant has no significant history of prior criminal activity. 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or any aspect of the circumstances of the offense favorable to the defendant which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance or that you agree on the same mitigating circumstance. The defendant has not taken the stand to testify as a witness during the sentencing hearing, but you should place no significance on this fact. The burden is on the state to prove any aggravated circumstance or circumstances beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. You will be provided a verdict form consisting of 6 pages. You have 2 sentencing options to consider on each count.
Much fewer
and
pages.
You are not required to deliberate on these sentencing options in any particular order. The options are as follows. Verdict, life imprisonment or life imprisonment without possibility of parole. If you do not unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict shall be as follows. We, the jury, unanimously find that the punishment shall be life imprisonment. If you unanimously determine that a statutory aggravated circumstance or circumstances have been proved by the state beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to imprisonment for life without possibility of parole or to imprisonment for life. In choosing between the sentences of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory circumstances or circumstances proven by the state beyond a reasonable doubt, and any mitigating circumstance or circumstances. In your verdict, you shall reduce to writing the statutory aggravated circumstance or circumstances so found, and shall return your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict should be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravated circumstance or circumstances beyond a reasonable doubt. here on the verdict form, you would list the statutory aggravated circumstance or circumstances found. You shall then indicate on the enclosed verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. The verdict must be unanimous and signed by each juror. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. You will be provided with a form for all possible sentences in this case. The jury will check the appropriate verdict on the form for each count and complete the form as directed, and each juror will sign the verdict form. The other forms are to be left incomplete and unsigned. Your foreperson will preside over your deliberations, and when you have reached a verdict as to the sentence, you will return to the courtroom and your foreperson will announce it. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them, and have attempted to read this charge to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the charge in this case is herewith handed to you together with the verdict forms for the punishment for each count and the exhibits. You may now retire and consider your verdict. You can step down the hallway with the court officer.
All right, I realize it's a done deal and it's too late, but I believe the state stepped in it there and it could have cost them a lot. It could have cost them life without parole. But defense didn't catch it. They missed it. And I'm not a Tennessee lawyer. I'm not a lawyer. I just pretend to be one.
Anything further from the state?
But I caught it.
Need to be a hearing, sentencing hearing. If we had a date, we might also be in our
Yeah, in terms of merger and count one,
and
whatever happened.
yes, Your Honor, and
I think we can look at like the week of the August 3rd, like the 5th maybe, or somewhere around there. Discuss that with
yes,
you.
that's all.
Anything further on the jury charge, Mr. Brand?
No, sir.
Okay. All right, we'll need a recess.
Okay, so while we go to recess, let me hurry and explain why what I'm talking about. Just let the audio die on this one. He's gone. Okay. We're going to mute that for just a second. Let me go back and take you back just to couch this in the situation we were in. This is a sentencing hearing where new evidence is put on. Opening statements are offered. Closing statements are offered. In the state's initial closing statement of the sentencing hearing, this is what we heard. And we're going to go there here real quickly. Let me let's see if we can get this queued up here.
Today is 51 years before parole eligibility. That's a long time. It's a really long time.
Listen carefully.
But contrary to what Mr. Brand said about
Okay, contrary to what Mr. Brandt said, Mr. Brandt is on the defense. So he's saying, as opposed to what the defense said, I'm going to shed some light on this issue. Mr. Brandt did not bring this up. They didn't open the door to this, but listen.
Life without parole being the harshest penalty. The harshest penalty wasn't asked for, the death penalty.
Boom. The death penalty. Why is he talking about the death penalty when it was never on the table in this case? Did a quick look, pulled up in Tennessee law. We're looking at Tennessee Criminal Code 39-13-207, Part A1, the last sentence of this paragraph. This is code specifically relating to sentencing where death penalty is not sought. It can't get more specific to this case right here. I'm going to read you, and I quote. The sentencing proceeding shall be conducted in accordance with 39-13-204, excluding references to the death penalty. Why is that important? Why is that important? Because the jury now has in their mind the idea that the highest charge they can bring back legally is a compromise. It's a settle. It's like, well, we're not doing the worst. He could have deserved the worst. We're in the middle now. It is so bad. What should have happened right there is the defense should have said, objection, Your Honor, objection. They should not be bringing this up at all. This is like having a lesser included on the top end that you can't reach and then saying, oh, we went lower. It's okay. So if they had objected and the judge said, it's fine, go ahead, then that would be huge grounds for appeal because you've got the law right here in front of you that says, in this situation, this is what has to happen. And they violated it. That could have, it could have, been a major appellate issue. Instead, what did the defense do? They're like, oh, you're right. We're not asking for the death penalty, though. That's not what was never on the table. They missed it. A missed opportunity. Is this ineffective counsel? No, I don't think it is. Because they did not object, it was not preserved for the record. It was not preserved for the appeal. And so it's Hakuna Matata. It's in the past. It doesn't matter. It's in the past, right? It's too late. You had the opportunity to object. You didn't. We proceeded on. We can't go back there now. We can't unwind everything that happened since, fix that, and then move forward again. We're not going to unweave the loom and go back and fix that stitch because you should have objected when it was there. I'm surprised they missed that because that's big. I mean, the only issue defense is fighting for right now, there's one thing they want, and that is for the jury to come back with a life sentence. That's their want. They want the life sentence, and they missed the opportunity to say, hey, objection. You can't set the scale outside the parameters of this court case. You can't include death penalty so the jury thinks that we're going to settle with life without parole. Anyway, so, but it's too bad. I guess the lawyers are not paying attention or not watching us. Maybe we'll talk to Josh about it tonight. We'll see what he thinks. Now, there was a point, and I'm sorry, I got a little carried away reading this and just chasing the law because it seemed like that was the case, and it was. There was a point instead when the defense got up, they sort of admitted. Oh, well, by the way, he did it. So punish him with what was it? Life in prison instead of life without parole. You generally don't want your defense team to be like, our guy's the bad guy. Yeah, you got him. You got him. I don't have that queued up here, but that happened to some extent. I don't remember the exact words on that. I'll see if I can get Josh's take on the mentioning the death penalty. If you'll give me a minute, I'll see if I can find it. Hold, please. Let's see where are we at. It was in the response. It wasn't very long, so. Okay, state got up. Defense just talked for a minute. We might watch all of the defense closing here. Just one second. Okay, so we're coming in on the moment the defense takes over for the last time they get to talk to the jury. We have captions on here so we can hopefully.
Life imprisonment is an appropriate punishment for Mr. Taylor. And punishment is what it is. It is not a minimum get off easy kind of sentence. It is life in prison. 51 calendar years at best. That's if you make parole at 80, if he's 30 right now. Yes, in opening I said it's the harshest you have is life without the possibility of parole, and there is death penalty, but this isn't a death penalty case. We knew that at the beginning. It's the harshest option you are considering today. And life imprisonment is incredibly harsh. Living in a concrete box for the next 51 years, that is punishment. He's not getting off. He's not getting off easy. You're not letting him go. He's not walking out of this courtroom. Likely for the rest of his life. Now, looking at the jury verdict, it occurs to me that
listen to this.
Maybe there is some consideration from the jury that you all think Mr. Taylor intended to kill baby Ivy and maybe didn't have the intent to kill Jade.
So you're saying there's a chance, if you cite the Dumb and Dumber reference there. Yeah, maybe. That's exactly what the jury said.
But he knew he was killing her, or some version of that. Obviously, I'm not in the jury room. I don't know if that matters in your deliberation for this part of it. But if we're talking about what are the worst of the worst of the worst crimes that you get the worst of the worst of the worst punishments, this was a long, incredibly detailed, complicated trial. And you guys heard a lot. You can consider all that when you're making your determinations. The reason that we put on some proof about who is Blaise, what was his family like, what's his upbringing like, what's his community involvement like, is there's kind of a, I don't know if it's a saying, it's something that's talked about in work when you defend someone sitting at that table, that we are more than the worst thing we've ever done.
Hold please. Hold please. This is what we tell ourselves to sleep well at night. He's saying, we are more than the worst thing we've ever done. Who's ever done? Who did what?
We're people. Blaise is a person. He's got a family. He had a great childhood. He did well in school. He was an all-star athlete. Yeah, he did something horrific.
Oh, tell us more. Stop. Pause. He did what? We've heard he's a star student. Tell us more about what you just said he did that was horrific.
Nothing that can happen here is ever going to change that. Nothing. And he's going to spend the rest of his life in prison no matter what. So you all can go home and rest assured that no matter what you do here today, he's going to spend the rest of his life in prison.
For something his own attorney says he did.
It doesn't require life without the possibility of parole to send that message, to send that punishment. It's not either we let him off easy or we have to punish him the worst of the worst of the worst of the worst. He's being punished. He's getting the message.
He's not going to do that again.
But he is not someone who has spent his entire life as a criminal. He is someone who's had a good life, who's done good things. I don't have anything to say about it. He did something terrible. There's, let's call it what it is. When you hear the jury instructions, there's going to be a lot of talk about aggravating and mitigating factors. And I said this in my opening, and I'll say it again. If you find aggravating factors, you don't have to find that he gets life without the possibility of parole. It's just something you can consider. Life imprisonment is punishment. It's life in a box. It's life in a prison. It is a message. It is a lot. It is enough. And we would ask you to return for your sentencing that be the appropriate sentence in this case.
All right, and that takes us back to the present time where where we're waiting as the jury is out deliberating. Right now, they have been deliberating for about 11 minutes, 11 and a half minutes on the verdict in this case. And so we're going to, we've got a hot mic in court. Hang on. I'm not sure. Okay. I know we've got the civil hearing for Karen Reed. I've got half an hour before I've got to be in like the green room for Courtroom Confidential for tonight. Not guilty. Let's go. Yeah. Kurt, good to have you here on Civil Law in the house. Is it normal for the jury to decide the verdict? It depends on the state and the laws of the state. I would say it's normal in Tennessee for the jury to decide the verdict in this type of trial. And I think they make a recommendation. The actual sentencing is going to be done, like the judge said, probably early August, in a month from now or something. Save read for tomorrow morning. We'll need some laughs. I can do that. That will make perfect sense. I know, I wish I had like 6 cameras in this courtroom. I want to see everybody. When I'm king, guys, when I'm king, I will make the law, and we'll have all the camera angles in court of everything, even the federal stuff. This is the punishment phase right here. Deliberation and punishment phase. Remember Todd Mullen's face when the attorney said he was guilty? I do. And then remember the 18 months the judge took to decide the appeal? When he took something under consideration for a new trial? Yeah, it's not going to be used as... And also... Kurt, he said it during the closing arguments. It's not like he said it during the evidentiary portion where the jury is still hearing evidence for the decision. It's not evidence. Melissa Ann, Flow State. Do we get verdict music again? No. I'm sorry. Just the one time. Have you ever heard a defense attorney admit their client did something horrific before the appeal? We've heard it a couple times. Yeah, this is not the first time it's happened. I'd say it's rare. They only have 6 pages, mana, only 6 pages to deal with. And I think only 2 of them are necessary for them to reach the verdict. Defense did say death penalty also. Instead of objecting, they adopted the state's error. Yeah, I'm going to be giving out land grants and everything when I'm a king. It's going to be great. We're all going to live high on the hog, cake every day. Yeah, I think the better way, I'm gonna kill this hot mic just for a minute. The better way the attorney should have mentioned that is acknowledging the jury's verdict and accepting it, saying we accept that, instead of saying you're right, you got us, we tried to pull a fast one, but you saw through it. I think there would be a better way without like, all right, okay, but it was one bad thing. It was just one bad thing. It's not that bad. I want to be the one that walks up and down the town square with my bell yelling, shame, shame. Oh, we're going to have stocks and everything when I'm king. It's going to be great. We'll bring back public shaming for sure. I can make you a Lord Recovery Addict like I did my son for Christmas. Well, you're at it. Name a star after me. No, just kidding. We're all in good fun. I'll be the king of court cameras and audio. My own little domain. You got us, but it wasn't that bad. Considering his other stuff, I mean, look at his accomplishments. He's got a great career. He did well in school. He was a great sports player. Not so good that the Saints wanted him, but good in high school and good enough for college. There's at least that. Somebody just came in. Sounded like the judge's. Do you think they could get a verdict in under half an hour on the sentence?
Just a little bit, but I'm sorry I picked it up.
They are.
Well, did somebody say something? Sorry. At this point, I pick it up.
You're gone.
You want to make it? Yeah.
It's loud. We've got the volume cranked a little bit so we can hear what's going on with the hot mics. There is some movement, a little bit of camera shake. We're hearing doors open and shut. Kurt says, I haven't even done one murder yet. I'm falling behind. Kurt, you might have to watch the podcast tonight. As we found out from somebody down in, I don't know, Georgia or Florida. I think it was Georgia. He allegedly killed his girlfriend and then died while trying to hide her body, dispose of the body. He had a heart attack. So before you go and commit that crime, make sure you check in with your doctor. Make sure you're healthy enough for crime, because it's not for the weak. Apparently, not for the weak. I'm sure you're plenty strong. Not a recommendation. Podcast Thursday. I'm sorry. We're going to be on with Courtroom Confidential here in 1 hour from right now over on Courtroom Confidential. Ask your doctor if murder is right for you. There's the one-liner I couldn't quite put together, Kurt. Thank you for hitting that one. Ask your doctor if murder is right for you. One out of 10 doctors recommends. Oh man. So if I start really doubling down and working on my health, it's not because I have somebody in mind. I don't have a little blacklist that I'm like, hey, okay, I'm just getting ready. It's not that. It's just want to be healthier. I say as I bought Mountain Dew today. If you had a doctor who prescribed murder, you may be entitled to compensation. Let the class action lawsuits ensue. I need that on a mug. Let's do that. Let's make some merch. We haven't made merch in like 2 years. Michelle Mitchell, I see what you say. I think you could read it both ways. But when you can read it both ways, that's something that you can argue to the judge. The law, Tennessee Code 39-13-207, saying the sentencing shall be conducted in accordance with 39-13-204, excluding references to the death penalty. It could say excluding the references in 39-13-204. but that excluding the references, we had references to the death penalty in the hearing, and I think that does present room for argument. Should have, had they objected. Caution: murder may be bad for your health. There goes another company benefit, right, Kurt? All right, we are, if we get all the way to 6:15 without a verdict, as far as the recommendation for the sentencing, I think we're going to wrap it up, and we'll cover it on Court and Confidential tonight, if it comes in. Everyone's just sitting around waiting. I think they expect a quick result as well. We're 22 minutes and 45 seconds into deliberation. Texas Brand, if you've missed it, if you're just joining us this afternoon, in the Tennessee versus Blaise Taylor trial, the jury has returned a verdict earlier this afternoon. They came back with 4 guilty verdicts for the 4 charges. Everything was as charged, guilty as charged, with the exception of charge number 1, which was the first-degree murder of Jade. That they came back with a second-degree murder, which would mean that they found that it was not premeditated in Jade's case. He wasn't like trying to kill her necessarily, but premeditated in the charge for the unborn child. So we got those 4 guilty verdicts. We then had a hearing where the state and the defense put on witness testimony as allowed, or victim impact statements as allowed under Tennessee law because of the aggravating factors in this case. You guys remember we did the demonstration about the lesser includeds, and the aggravating factors is when you have the extra peanuts. Okay, I need a bigger, smaller candy bars or a bigger hand. Just can't hold 4 at a time. So we have the Snickers extra right here. The aggravating factors of committing the felony, or committing the murder while committing another felony, the child under the age of 12, that entitled them to present that witness victim impact statement to the jury for consideration. So they presented that. Defense presented mitigating factors, which was, he's been a good boy and my mommy loves me, to the jury. They consider that as well. And then now they're deliberating. The jury's deliberating on the sentence. There are only 2 options they can return. One is life in prison, which in Tennessee would mean at age 80, 51 years from now, Blaise Taylor would be eligible for parole if he's good and doesn't have a lot of problems in jail, and he lives that long. The other option is life without parole, which would be just what it sounds like, and it would be he would spend the rest of his life in the correction system and never be released. Are we killing for candy? Because I'm ready to start negotiating. We were explaining lesser includeds. We can do it one more time while we wait. Let me turn this down a little bit. In this case, we had a lot of lesser includeds. The state charged as the 2 top crimes, they charged first-degree murder for the death of Jade and for the death of her unborn child. That first-degree murder, I'm going to equate to a Snickers bar. Snickers is a wonderful candy bar, not a sponsor, that has 4 main ingredients. We have chocolate, we have nougat, we have caramel, and we have peanuts. These are the elements of the charge. So Snickers is the charge. The state is charging Blaise Taylor with committing Snickers. For the jury to find him guilty of committing a Snickers, the jury has to find that all 4 ingredients are present. If the jury tries this and says, tasty, I like what you're selling us, state, but I didn't taste the peanuts. If you didn't taste the peanuts, there's a lesser included of Milky Way. Milky Way is a Snickers bar without the peanuts. It has chocolate, it has nougat, it has caramel, but there's no peanuts. This is a lesser included of Snickers. So the jury might be able to find him guilty of a lesser included. This would be, say, like second-degree murder. If they did not taste the caramel either, there's another option, right? We have Snickers, Milky Way. Now we go down to a Three Musketeers. A Three Musketeers only has chocolate and nougat. Those are the only 2 main ingredients in this. This would be a much lesser. This might be a manslaughter charge of some sort, or reckless. There's a couple different options because there are actually several lesser included there. That's going to be a lesser included of a Milky Way charge or a Snickers charge. And they might also say there was no nougat, state. I heard what you were telling me, but I just tasted it. All I could taste was the chocolate. In that case, you're all the way down to the Hershey bar. This is going to be I don't know, let's see what was the very bottom charge that they had included on this one. I think it was criminally negligent homicide. Right? That would be the chocolate bar, a lesser included of all these other charges. And the state asked for 2 of these. They got 1 of these and 1 of these. Nougat is a funny word. It is. I'll take 1, please. This analogy is insane. The worst part, Kurt, is nobody's thinking about what the law means. They're all thinking, oh, Snickers. Now I want candy. See? I told you. Kurt has discovered the insanity of our group. What's a Baby Ruth? I haven't worked it out that way because you start branching into, Twix is, completely out of the, yes, I have other candies. Twix is out of the question. You can't even bring Twix in because now you've got a cracker, caramel, and milk chocolate, which goes off one direction, which is just crazy. And if you want to get political, you could introduce Snickers White version. Snickers White, but that opens up arguments and discussions that we are just not prepared to have on YouTube once it gets there, because none of these lesser includeds apply if it's Snickers White. You can read into that what you want. All right, if you start trying to explain all law using candy as some sort of family tree, I'm staging an intervention. Thank you very much. Loves true crimes. You're so funny. Thank you. This is actually what made sense to me when I first was learning about lesser includeds, and there's still the issue of state law whether lesser includeds are allowed or not. Right? You don't always have lesser includeds, and if it's the lowest possible crime, there may not be a lesser included. What's the lesser included of speeding? Right? Not speeding. There's no lesser included to that. But there's a higher one. You might have reckless driving. Could have been, 25 miles over the speed limit. Reckless driving, lesser included would be speeding. Or I went to the candy store and said, give me one of everything. No, I did go. They didn't have any Snickers. I'm like, you can't be out of Snickers. I rode my e-bike there. I didn't pedal. I just pushed the button. And I'm like, you got to have Snickers. And the guy's like, yeah, I got Snickers. And he brought them out. And then the owner came out and thanked me for buying so much. Because it was like $23 worth of candy bars. Are you right off the candy because you're using it as a business prop? Yes, Kurt. Yes. I got a receipt. I turned it into my accountant. I wrote off the caviar too. So this is how we roll. Shelly Knuckles, Kelly, thanks for this awesome news. My mom finished her cancer treatment today. Mom, Shelly Knuckles, Mom, congratulations. Get feeling better, get your strength back, and many, many more years ahead. That would be wonderful. I drove the e-bike. Yes, I did. Right off the e-bike. Still seeing people walk around in court just a little bit. Some movement so people aren't leaving. LAK Wildflower. Thanks for the high five. I traveled I was traveling. I was not driving, Your Honor. I was traveling, as is my right as a living man. How do you keep the candy bars from melting? I wrapped them in the plastic bag they gave me, and I stuck them in my tail bag, and it was only about a 1.5-minute ride back. It's really close. I live really close to the gas station. Melissa, don't even think about it. I've tried your jelly beans. They are no good. Snickers with pecans was good. I've seen them. They were there. If you need one, I know a what is it? A Speedy Mart or something that has them. Okay. Y'all, this has been a great day for trial watching. We've had some excitement and some great arguments, some great evidence, and verdict music. Tonight at 7 o'clock, I'm going to be on with Josh from Courtroom Confidential. So what I'm going to do right now is wrap up our watch of the sentencing verdict watch, which the jury's out right now for. They've been out for 32, almost 33 minutes. And we'll be over on Courtroom Confidential in less than an hour. 45 minutes. So we're going to talk to you over there, and if there's a verdict, I'm sure Josh and I are going to cover it because we're going to be talking about the Blaise Taylor case tonight. And can you drop the link for Cece? Yeah, let's do that. If the mods can put Courtroom Confidential in there. I don't know, I'm hearing all these doors open and close in the court. I'm thinking the judge might be coming in, but not. Let me see if I can also portal us. I think I can portal us to Courtroom Confidential. If not, I'll call Josh and see if I can get access. Yeah. All right, he's already got the thumbnail up, so we've got a portal set up. As soon as this is over, it will portal you right over to Courtroom Confidential, where you can hang out with all your friends here and our friends over on Courtroom Confidential side. That is a fun place to go. I love being invited over there. Josh, his wife, Kai, they're absolutely amazing. I love the whole team over there. So that's it. It's 6:15. Got to stay true to my word. If history repeats, they'll be back with this decision before you can sign off. Did I say Tiffany was on here? Who did I say his wife was? Josh, his wife. Kai is not his wife. Kai's just like the best assistant known to man, which if I could afford her, I would steal. Josh and Tiffany and Kai. Who did I say? Did I say my wife's name? That'd be terrible. All right. Maybe we can watch you with a Josh. Yes, we'll watch with Josh. We'll be back there in a little bit. I didn't punctuate correctly. I didn't put the comma in place. That's what it was. I wear many hats. All right, tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. I will be live on Courtroom Confidential on their channel, which we are linked to. Portal's open for that. We'll be there in about 44 minutes. So please join us over there. We'll probably get this sentence verdict in while we're waiting for Courtroom Confidential to start. So we'll get to be able to sort of break the news when Josh goes live. That'd be great. We'll talk about this trial. See you guys in a little bit. Have a good one. Bye-bye.